Okay.
On the record.
Okay. Well, you want to do the call for the morning?
Yes, Your Honor. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you, and good morning, and welcome to the Massachusetts Appeals Court oral argument session for November 16, 2020. As you know, the argument is being held on Zoom and being live streamed simultaneously on the Appeals Court's YouTube channel. We will follow the same rules and customs as in the physical courtroom, except that you're free to remain seated during the argument. Once we get going, the clerk will display a countdown clock in where the seal is. And as usual, each side has 15 minutes. There's no rebuttal. Only one advocate will speak at a time, and the others will be muted while the one attorney is speaking. But please stay on the video, and at the same time, remember that we can see you. So please, keep reactions and gestures to a minimum. In addition to being live streamed, the argument is being recorded and archived, so it will be accessible to the public later as well. As always, we've read your briefs and we're familiar with the case. Although you're free to use all 15 minutes, there's no penalty for ending early. And so with that, we'll call the first case, which is Commonwealth versus Kim, 2019 P1603. Attorney, right, this is a Commonwealth appeal, so Attorney Delator.
Correct, Your Honor. Good morning, Your Honors. May it please the court, Monica Delator on behalf of the Commonwealth. I would also like to recognize Assistant District Attorney Chris Boutan, who is the trial prosecutor in this case and is watching via the live stream. We are respectfully requesting this court to reverse the motion judge's order, allowing the defendant to withdraw his admission and ordering a new trial. Regardless of this court's determination of admission counsel's advice, what is clear here is that the motion judge abused his discretion in finding that the defendant suffered prejudice for 3 reasons. First, because the motion judge found special circumstances that are not recognized under the case law. Second, because the defendant did not present an available and substantial defense. And third, and most importantly, because in the totality of the circumstances, there was no reasonable probability that the defendant would not have admitted to sufficient facts and would have insisted on going to trial. In regards to the special circumstances, neither of what the motion judge found to be special circumstances here are in fact special circumstances recognized under the case law. A desire to be a United States citizen is not a special circumstance, and the Commonwealth did bring the court's attention to a case of Commonwealth versus Casimir, which does note that the potential of being denied citizenship is not sufficient to be a special circumstance. Understandably, that is a 29D case. However, that same rationale should be present here, where there's a hypothetical situation and not a circumstance that actually faced the defendant that is not enough to be a special circumstance under the case law. In regards to the defendant's current status, that is also not enough on its own to be a special circumstance, as that doesn't indicate on its own whether the defendant would place a particular emphasis on immigration consequences.
Ms. Delator, can I interject a question, please?
Please, thank you.
Have there been any cases, reported cases, where a judge's allowance of a motion to withdraw a guilty plea on Padilla grounds has been reversed? In other words, has an abuse of discretion in this context been found in any reported case?
I don't believe I can think of one off the top of my head. I would note that cases like Commonwealth versus Utley note that the determination is individualized to the case, relying on the specific facts. And most of the determination rests on the totality of the circumstances. And I agree that they do often affirm a motion that has been denied. I can't think of one off the top of my head that has been a published case that has reversed where it has been allowed. But again, I would note that that is specific to the individual facts of within those cases.
How about an unpublished case? Can you think of any of those? If not, that's fine. I'm just curious.
I cannot think of one off the top of my head. Yes, I apologize, Your Honor.
And the reason that is that there's a highly deferential standard of review. There's got to be either clear error or error of law. And I guess what I heard you arguing is that we have an error of law here.
Correct. Understanding that there is a substantial deference to, in this case, where the motion judge was the admission judge here. Even so, it is the Commonwealth's position here that the motion judge did abuse their discretion in allowing the motion here, and in particular in finding prejudice here as well. In regards to, I would just note that in terms of the special circumstances, even if this court were to find that there were special circumstances, that does not necessarily require a finding of prejudice. Prejudice determination rests on the third step of the totality of the circumstances to which immigration consequences are given substantial weight. In addition to that finding, the motion judge also abused his discretion in finding that the defendant had presented an available and substantial ground of defense. Preliminarily, this was a strong case for the Commonwealth, and in considering an available and substantial ground of defense, that is an important factor to consider. The only defense that was argued in the motion to vacate that was also argued at the motion hearing was mistaken identity as to the defendant, and that was argued through the testimony of the defendant's friend. I would note primarily that the defendant's friend had actually testified that the defendant did touch the victim. And so with that testimony, that defense of a misidentification as to the defendant was no longer available.
What about the defense that has to do with the application of a lesser included offense of simple assault and battery?
And my understanding in terms of that argument is the defendant is arguing that the indecent assault and battery was not by definition indecent here, but it is well recognized under the case law that the intentional and unprivileged indecent touching of the victim is an indecent assault and battery. Under Commonwealth versus Malo, as well as Commonwealth versus Mosby, it's clear that that includes the buttocks in terms of the body parts that are included.
But does it include the belt area, which is what the friend testified to?
That's true that the defendant testified to that. I will note that that defense, in terms of it being a different location of the body area, was not argued in the motion to vacate as well as at the evidentiary hearing. It's also not argued in the defendant's brief. I would note that it's the defendant's burden to bring that defense and argue that that's available. I would note that with the circumstances here, it may be possible that that was still an indecent assault and battery, as in the defendant and the victim did not know each other, which under Commonwealth versus Cologne is a factor to consider. And the defendant had also made statements that perhaps could push it over to also be an indecent assault and battery as well.
Are you, we skipped right to prejudice. Are you conceding that there was ineffective, that there was, you know, the first prong, that the advice was not good?
No, I'm not conceding that point. There are a number of cases that note that it's dispositive in terms of prejudice. So regardless of this court's determination there, that point is dispositive. I would note that a couple of things in terms of the first prong, which is first that its case law is unclear in terms of if there's admission is comparable to clear deportation consequences as the result of an admission, if the defendant had to be advised regarding exclusion from admission. It was clear they had a discussion about travel restrictions. It's clear that the defendant thought that he was deportable, and that's clear from the discussion during the admission hearing as well as the testimony during the motion hearing as well. And I would point the court to cases like Commonwealth versus Lopez, which was last year, where this court did not decide. I apologize, that is not in my brief. The citation is 96 Mass Ave Court 34. Well, this court did not decide whether plea counsel had to provide that type of advice, but instead decided the case on prejudice. It is the Commonwealth's position that if this court were to find that that advice was required, that advice was given here. I think that can be inferred from the discussions during both the the admission hearing as well as at the motion hearing.
During the plea hearing, the judge said a couple of times that he really didn't want to hear about immigration consequences because he wanted to treat everybody the same. What, if anything, could the Commonwealth or the defense counsel have done at the plea hearing to make a record of what advice defense counsel did or didn't give to the client?
Well, I think there are discussions in terms of what had occurred at the admission hearing. There are discussions that the plea counsel was stating, or admission counsel was saying that there was a delay because the defendant was under the realization that he was going to be deported to South Korea, and that there was this discussion between the defendant and the defense counsel. So I think that does help make a record here. The motion judge here did state that he was not taking immigration consequences into account, I believe, mostly in determining if there was going to be a continuance with this case, not so much in terms of not allowing the defense counsel to bring those consequences up. I would note that both the defense counsel and the Commonwealth noted that they had taken immigration consequences into account, particularly in discussing a disposition, but again, also in terms of the delay here. I would just note in regards to the prejudice prong and the totality of the circumstances here, even assuming if the defendant had received proper was properly informed of the immigration consequences, it's not a reasonable probability that the defendant would have gone to trial. I do think what is important to think about in terms of prejudice is that it is clear that the defendant was under the belief that he was immediately deportable, that at the admission, the defendant was aware of the possibility of being deported. So if he had received the accurate immigration advice, he would have been informed that he was instead inadmissible, that he would have been deported, that he would have been placed in removal proceedings if he had come back into the United States after he had traveled internationally. It's the Commonwealth's position that at that point, that difference where there are less severe immigration consequences with the totality of the circumstances, the defendant would not have insisted to go to trial. The primary concern of the defendant was that he did not want to have to register as a sex offender, which would have been required under a conviction for indecent assault and battery. That's discussed on page 60 of transcript volume 4. That was
it seemed like travel was a pretty important thing for him too. Mm-hmm. And you know, this is a complicated law, but so what you're saying is that the admission of sufficient facts to this crime would be automatically bar re-entry, but it wasn't automatically deportable?
That is my understanding, Your Honor. This is a crime of moral turpitude that was not committed within the first 5 years that the defendant was in the country. So my understanding is that it was not a crime that was practically inevitable. The defendant was going to be deported, but instead was inadmissible.
But so then the really bad advice was telling him, oh, if you just get the court's permission, you can leave the country.
That was the advice that was given, though I do, I think a couple of things where that wasn't automatic in terms of he would have had to travel in order to be placed in removal proceedings. I do think that the defense counsel was correct in the sense for the state parole conditions, he would have had to check in with the court in order to have permission to travel. But there are indeed discussions there's in the testimony of the motion hearing discussions between the defense counsel and the defendant about that there would be restrictions to travel. In addition to the defendant's concern, again, with traveling and with the registering as a sex offender, I just note that the registration as a sex offender was a concern because of the defendant's application for citizenship. He was aware that that would impact his application for citizenship. Additionally, that the second benefit that the defendant received was that he did receive a continuation without a finding when the sentence has a maximum sentence of 2 years. That was also important to the defendant because he was concerned about how the conviction would impact his citizenship application. And the Commonwealth case here, again, was strong. The victim was present for trial. She had flown up to Boston from Florida and was willing to testify. There were 2 police officers as well that were present for trial and was willing to testify as well. And finally here, the defendant did sign a waiver of rights form that acknowledged that he understood the immigration consequences, including the exclusion from admission. Understandably, that's not a substitute for appropriate advice in this case, but it can be considered for prejudice, and that's in the Commonwealth appendix on pages 33 to 34. I apologize, Your Honors. Was there a question? I misheard, excuse me. As such, under those circumstances, it was not rational for the defendant to reject the admission and instead to go to trial. And the defendant did not meet their substantial burden in showing that they suffered prejudice here. I'm happy to answer further questions, but the Commonwealth will otherwise rest on its brief.
Seeing none, thank you.
Thank you, Your Honors.
We'll hear from counsel for the defendant, Attorney Self.
Good morning, Your Honors. May it please the court. My name is Rachel Self. With me is Attorney Laura Mannion, and we represent the appellee JEONG Kim. Your Honors, substantial deference is given to the motion judge when the motion judge was the plea judge in the case. In this case, 3 months after the plea was taken in this matter, Mr. Kim was finally introduced to the reality of the fact that taking this plea would render him deportable from the United States. And that is because he did travel outside the United States, and he traveled because he thought that he could. And the reason that he thought that he could was because he did not receive adequate advice from his counsel at the plea stage. He received ineffective assistance of counsel at the plea stage of this case, but also that ineffective assistance was widespread throughout the case. This is a matter in which the Rule 30 motion was filed based on ineffective assistance of counsel, because when all factors are looked at in their totality, it is clear that justice was not done in this case when Mr. Kim took this plea. In reviewing the plea transcript, there are numerous occasions in which it is clear that trial counsel was not prepared for trial that day. He showed up and he was anticipating a motion for non-suggestive ID. And the court immediately shut him down. And there was discussion about, oh, well, I didn't realize that's how that's done here. And Judge Somerville was very clear, no, this is how this is done here. And what eventually evolved in reading the transcript of the plea that day is that over the course of approximately 3 hours, there was back and forth and back and forth and back and forth between trial counsel, Mr. Kim, and the Commonwealth. And it was ineffective that all of those conversations for the first time were being had that day. When you represent a non-citizen defendant, it is imperative and vital that discussions about immigration consequences occur early and often so that the person has an ability to make a knowing, intelligent, and voluntary waiver of their rights when they take that plea or make that decision. In this case, we have very clear evidence that the client was not even aware that it was on for trial that day. The trial counsel had communicated with him about being in court that day the same way that he had at all of the pretrial stages. And ineffective assistance of counsel applies at all of the critical pretrial stages as well, as Your Honors are very well aware. And in this—
Counsel, I have a question. How do you get past the fact that at the plea hearing, plea counsel said, apparently in your client's presence, quote, "I think his loss of immigration benefits is certain, and I've told him that." How do you get past that?
I think that what Attorney Serpa, and just by using the word benefits, I think that it's very clear that Attorney Serpa was not fully vetted and familiar with the various consequences versus benefits. It appears that what was discussed at length was Mr. Kim's inability to apply for citizenship and the difficulties that he would have with doing that. But at no point is it clear that Attorney Serpa, and in fact, in the motion for new trial hearing at page 73, I in fact asked Attorney Serpa, so at the time that you took that plea, you were not familiar with the difference between inadmissibility and deportability? And he answered no. So if Attorney Serpa wasn't familiar with those differences, then there was no way that he could have effectively advised his client and educated his client regarding those differences. And
although if he thought that they were both consequences, and another point in the record, he says he's now facing deportation to South Korea because of this. And I asked for an 11-month clock because on the minuscule, if non-existent possibility that will somehow influence an immigration court, it seems like counsel was thinking that this was going to be automatically deportable. Like
Yes.
It seems like counsel, which is even worse. I mean, and if he gave your client that advice, wouldn't that cover it?
No, Your Honors, it wouldn't, because the advice that's given actually needs to be the correct advice. And if an attorney is not familiar with immigration consequences and how they affect a particular immigrant client, it's their duty, as is borne out in Padilla and in Clark, where the immigration consequences are clear. And it's our position in this case that that a crime of moral turpitude to a lawful permanent resident, if they choose to travel and leave the country and come back in, makes them inadmissible. And if the court looks at the Commonwealth's record appendix at page 115, it'll see on the back of the card that Mr. Kim was handed by CBP, do not admit LPR, meaning he was at that point placed into the process of deportation commencing against him, okay? And
Ms. Self, if I could interject a question, please.
yes,
A continuation without a finding for 11 months, I consider to be a fairly favorable disposition in a case alleging indecent assault and battery on someone under 14. Would you agree with that?
it would if the person wasn't considering all of the other factors. And as the court, and yes, Your Honor, it would be. However, when you're representing a non-citizen client, you need to take into account the varying balancing tests that apply to that client versus the average defendant. There are, as the Leverenko case tells us very clearly, you need to do the balancing test from the perspective of what the immigrant would suffer, not necessarily what the average defendant would suffer. And so in this case, Your Honor, when the court did, and to your earlier question, Justice Kinder, has there ever been a case in which a motion judge has been flipped on a motion for new trial where they've allowed it? The cases in which motion judges get flipped when they allow motions for new trial have all been cases where there wasn't an evidentiary hearing. In this case, we have 3 months after the fact where this client took this plea, 2 months after the fact, coming into court and asking for permission to travel because of the probation conditions. Common sense simply does not bear out that everybody knew what they were doing in this case, because if the client knew and actually had an understanding of the consequences, he would not have decided to take a vacation with his friends in Europe. This is not a situation.
But we got to talk about what he was thinking when he pled guilty, when he admitted sufficient facts, though, right?
Absolutely.
On that moment.
At that moment, Your Honor, I think he had no idea what was going on. And that bears out in the record. He even states at that point that he was thinking that he was there for the non-suggestive ID. And in the middle of the colloquy at the plea hearing, he says, wait. And at that point, it's clear, and this is on page 36 of 50, he says, wait. And then later, and a little bit earlier, right before he says, wait, the judge has said, so far as I'm concerned, and this is in the middle of the colloquy, Your Honors, if he doesn't go through with this, we're going to bring the jury up and get this thing going forward. And he did not feel that his attorney was prepared for trial that day. And we're all very familiar on how an attorney appears for trial when they're ready for trial. You have your trial binder, you're ready, you have your witnesses, you've spoken with the witnesses at least. You've met with the client in your office, you've prepared the client for trial. And he hadn't even advised his client what the maximum sentence in this case was. That didn't even happen until the plea colloquy when the judge went over that with him and said, have you advised your client what the maximum sentence in the case is? And he said, no, Your Honor, but I can tell you it's 2.5 years. This is not a situation where—
I'm sorry to interrupt, but again, the prejudice though isn't that counsel wasn't ready to go to trial. The prejudice that's alleged here is special circumstances with respect to immigration consequences. How do you respond to the Commonwealth's argument that that wanting to get citizenship has not been recognized as a special circumstance?
Your Honor, what I would state is that if the special as the Commonwealth is with regard to their position that the special circumstances were the citizenship, there were other special circumstances here. And those were the fact that in this situation, the Commonwealth in their own brief actually conceded that special circumstances were arguably present, but that it still would not have been reasonable to go to trial. This was a client who had lived here since he was 15 years old. He had no family in South Korea. His entire life he had lived with his family here in the United States. And the other thing is you don't need all three. You don't need to show special circumstances, and you don't need to show substantial ground of defense, and you don't need all three. You only need to show one. And in this case, there absolutely were arguably special circumstances present, but there was also substantial ground of defense. And the motion judge, who was also the plea judge, who heard in a very lengthy evidentiary hearing after an hour and a half of testimony by Mr. Kim and Attorney Serpa and the witness who was called, who could have been called at trial had trial counsel been prepared and ready for trial. And we hear in the testimony that Attorney Serpa had asked Mr. Kim that day, on the day of the plea, could your friend get here today? Do you think he could make it up here? There was no preparation for this. And so based on the fact that, and we really need to look at all factors under Rule 30 as to whether—
So what is the defense that was missing here? Substantial defense. The judge just said substantial defense, doesn't say what it is. So what is it?
Your Honor, at this point, it's our position that the substantial defense, it either could have been mistaken identity, or it could have been that it wasn't necessarily, it was a he said, she said case. So had the case gone to trial and and Mr. Kim wouldn't have even needed to testify at all if he didn't want to, but he certainly could have testified to the fact that he believed this was his friend that he was meeting up with later that night. Mr. Eng could have testified as to what he saw, and then the victim obviously could have testified to what she felt. But there were no aggravating factors here. And to Ms. Delatour's point with regard to the Mosby and the Mello cases, there was also an argument that perhaps this thing could have been directed out with regard to the indecent side of it. And because there were no aggravating factors, the colloquy was simply, and we have to consider what was read in the colloquy when we're considering what the evidence was at this point. In the colloquy, it was simply that he approached her from behind and smacked her on the buttocks with an open hand. So it is whether or not the judge, who also heard from the victim at the plea colloquy and was familiar with the facts from the police report and heard all of this other stuff, what the judge would have done isn't necessarily relevant to what a jury would have done at trial had Mr. Kim's counsel been prepared and taken this case to trial. This was a very triable case, Your Honors. If the witnesses had been prepared and if the attorney had been prepared, it was a very, very triable case. And to presume that Mr. Kim got this great deal because he didn't need to register as a sex offender and he avoided 2.5 years in jail. Even Mr. Serpa testified at the motion for new trial hearing that he wouldn't have ever thought that jail was even on the table in this case, and that really he could have. And again, this goes back to the ineffectuality with regard to the advisals to a non-citizen defendant. If the conversations had happened early and often, not only with the defendant, but with the Commonwealth, a breakdown letter could have been presented. The Commonwealth was entertaining on the day of the plea to consider reducing it down to simple A and B, and perhaps a greater, a guilty A and B, so an up pleading to a lesser charge. And then they went and they spoke with the victim, and understandably so. There was significant influence there that day because she was there and she'd flown up from Florida. If the work had been done prior to that, it is entirely possible that the victim could have been satisfied, the defense could have been satisfied, and the Commonwealth could have all been satisfied. But when you show up on the date of trial, when everybody is there, and Ms. Delatour can say this was a strong case for the Commonwealth that day because the witnesses were present. Well, yes, witnesses being present is necessary for the Commonwealth to answer ready for trial. But if the defense had also been ready for trial that day, it would have been a very triable case. And so to that point, you know, there were things that simply didn't happen. And when Judge Somerville heard all of the evidence at the evidentiary hearing, which was not a short hearing, Your Honors, this went on, it was a few hours of the day. He took it under advisement. He went back. He reviewed all of the evidence in his chambers and he allowed the motion. And I think that and the case law bears out that great deference needs to be given to the motion judge when he was also the plea judge. When the plea was taken, again, Your Honors, this isn't someone that was trying to fly under the radar for months and months. He knew when he filed this motion for new trial and it was allowed that it was only a few months later. The victim is presumably still on board. We will have a trial of this case if Your Honors affirm Judge Somerville's decision, and Mr. Kim will get his day in court, which he should have had. And so in the interest of justice being done, Judge Somerville made the decision that the motion should be allowed, and we're very grateful for your time, and we ask that you affirm Judge Somerville's decision.
All right, well, thank you for your argument. Thank you.
Live. And we are on the record.
Okay, good morning and welcome to the Massachusetts Appeals Court oral argument session for November 16, 2020. As you know, the argument is being conducted on Zoom and simultaneously live streamed on the Appeals Court YouTube channel. Nonetheless, we'll follow the same rules and customs as in the courtroom. Each side will get 15 minutes to speak. There's no rebuttal, although you are not required to stand. And only one advocate will speak at a time. The other one will be muted, but please stay on the video so we can know you're present. And at the same time, we can see your reactions, so please try to keep any reactions to a minimum. Once we get going, the session clerk will display the countdown clock where the seal is. In addition to being live streamed, the argument is going to be recorded and archived, so it'll be accessible to the public after this as well. As always, we've read your briefs and we're familiar with the case. And although you are free to use all 15 minutes, we won't hold it against you if you finish early. With that, I'll call the case, which is 2019 P1314, Commonwealth versus Roy. Attorney Maddox.
Good morning, Your Honors. My name is John Maddox for the defendant, Roy Goodwin. Mr. Goodwin contends that there was insufficient evidence of large capacity knowledge for the Section 10M convictions, and that there was insufficient evidence that Mr. Goodwin ever saw the magazines or had the opportunity to observe them or possess them. In that regard, I'd like to focus on the testimony of Ms. Peters in regard to her observations of the magazines and whether Mr. Goodwin had an opportunity to observe the magazines as well. She was asked if she'd ever seen the magazines before. This is on volume 2, page 96 and 97. And she said, yes. She said, I've seen them before. Where? In the residence of Roy Goodwin and at the dive shop. Then she says, do you remember? She was asked, do you remember the last time you saw them? Not offhand, no. Where at the house were they kept? They were kept, some were kept in the locked room with the rest of the guns. Some were kept in various places in the basement. What Peters does not say, that's her testimony in regard to Mr. Goodwin's opportunity to view the magazines and acquire large capacity knowledge. What she does not say is who put the magazines in the dive shop or the house, how long they had been there, who purchased them or owned them. All of that is guesswork. Also, her observation is undated. We don't know when this took place. This stands in marked contrast to the Cassidy case, which is the leading case on large capacity knowledge. There, the defendant purchased, owned, loaded, fired the magazines. You have none of that here, absolutely none.
What we do have, Mr. Maddox, as I recall from the record, is that this was the defendant's residence and he was a gunsmith. And I think one can infer from the record that he had a keener interest in firearms than Ms. Peters did. Why couldn't a rational jury draw inferences from that information?
Just because he's a gunsmith? We don't know if he owned these magazines. We don't know if they were his. We don't know who put them there. There were 3 people that lived there until mid-March of 2014. They were then discovered in the crawl space by the police on the 14th of April, so some 3 weeks later. But he has to have an opportunity to observe them, whether he's a gunsmith or not. And I'm suggesting that in this regard, the case is more like the Resende and Cintrone cases that I cite in my brief, Resende had insufficient opportunity to observe because he had just been given the gun, hadn't had it for that long. The magazine was in the gun. Cintron, that's a 128 case. He had had it for a few days, but we don't even have a timeline here. We don't know if it was a year or 5 minutes or what. We have no idea.
Can I ask a question, Mr. Maddox? It's sort of a threshold question. There's information that your client was incarcerated about a week before the search was executed. How was that presented to the jury?
I believe they were aware that he was in the House of Correction as of April 4th. So, but in any event,
was it stipulated? Was there testimony? How did they learn?
I'm sorry, Your Honor, I don't happen to remember. I apologize. I don't remember. I know that Ms. Peters left the house in mid-March. Mr. Goodwin was in the House of Correction on April 4th. The search was executed on April 11th. So there was at least a 3-week gap where he was not at the house. I'm suggesting that affects large capacity knowledge, also constructive possession of the various items.
And so, I mean, tell me why this is an unreasonable inference. I guess you're going to say that I'm piling inference on inference, but your client knows that Ms. Peters has broken up with him, and he knows he's going to be incarcerated. So he goes and hides the weapon that he's seen, that we know he's fixed, and the other more incriminating stuff that he owns somewhere where he doesn't usually keep them, somewhere that's very difficult to find. Why isn't it a reasonable inference that it's he who did that?
Well, I would suggest that that's speculation. The mere fact that he's broken up with Ms. Peters doesn't necessarily mean he's hiding these items. That may be where whoever put them there. I think that's one of a number of inferences you have to take. What we do know as a factual matter is that he had the firearm, the handgun, under a mattress prior to mid-March. So with that as the fact, and from that, the Commonwealth is suggesting that you make the inference that after Ms. Peter left and no one was there to observe this, after that took place, he then placed the firearm in the crawl space. The added inference that he also then put the magazines in the crawl space. There's no evidence to that. Nobody said that. And then
they're all found together, right? The guns are found with the magazines in the box.
Yes, Your Honor. The magazines plus the 12-round magazine, which fits the firearm, are in the box at the end of the 10-foot crawl space. So, but that's an inference. It's not a fact. Just because they happen to be near the firearm that used to be under the mattress, we don't even know if that's the same 12-round magazine that might have been in the gun. Ms. Peters does say that she observed him test fire that particular firearm, but she doesn't know if there was a magazine in it at that time. She was asked if there was a single bullet she remembered a single bullet being fired, but she doesn't remember how it was loaded, whether it had a magazine, a single bullet was put in. That's not, I forget what page that's on. That's on volume 2, page 84, the single bullet thing. So we don't know if that 12-round magazine was part of the gun or not. It was found next to the gun, and Lieutenant Brown couldn't remember if it was in the gun or not. So I'm suggesting that's a number of inferences, and I'm suggesting that piling inference upon inference is a form of speculation, and I cite the Coursing case in my brief for that proposition.
Mr. Maddox, if we assume for the purpose of this question that the defendant actually handled the high-capacity magazines, do you agree, if that were the case, that it would be reasonable for him to infer that they were high capacity from the markings on the exterior of them?
Yes.
All right.
They're 12 and 30 round magazines. Under Cassidy, those are obviously large magazines. That's the case law. I'm suggesting there's no evidence that he had the opportunity to view them. That's my argument. That this is all piling inference upon inference. It's a form of speculation.
Can I ask your absence defeat possession argument? Are any of those cases decided in the context where the defendant is the owner and one of two occupants of the house?
I'm trying to remember the facts of the Duffy case. I think that was I think he was the owner of that house.
You think Duffy, he was the owner?
But I don't think that's a dispositive factor, Your Honor.
No, that was the trailer park one.
Yes.
Well, I mean, isn't it though? I mean, it seems to me that most of when you say mere presence doesn't mean you're guilty, it seems to me like you happen to be, that seems to be the visitor to somebody's house. Just because they're there doesn't mean that they possess drugs. It seems like their presence is different from living there.
I don't believe I cited in the brief, but the Booker case is an example of where somebody is one of the tenants in the house, and that was insufficient to prove that there was constructive possession in that case. So I don't think it matters whether somebody is a visitor versus a tenant or an owner, regardless of how they happen to be linked to the residence. I don't think that those are dispositive factors. I think we've touched on the constructive possession argument. Another factor in constructive possession is the absence, of the 3-week absence, and it's unclear who would be. We know that Corey Goodwin, the son, was present when the search warrant was executed, but we don't have anything placing the Mr. Goodwin at the residence for at least 3 weeks. And that's why I'm suggesting it's akin to the Duffy and Uribe cases where there was a lack of surveillance linking the defendant to the residence. That's my argument there.
But if Ms. Peters testified that he told her regarding the defaced firearm that he had it for protection, and she testified that he'd had it for 2 years, wasn't it reasonable to infer that over that 3-week period, it would still be in the residence?
I believe that's true. I'm suggesting there's an insufficient link of him to the contraband, including the firearm. That's my argument. I'd also like to touch on the improper storage argument. In regard to improper storage, I filed a 16L letter with the Goodrow case, which is somewhat similar. I'm suggesting, as I argued in the brief prior to Goodrow coming out, that 131L requires a locked container, and I'm suggesting that the locked house plus being hidden in a 10-foot crawl space equals a locked container under the statute. And in that regard, the Goodrow case is helpful because that was a locked gun shop that was then unlocked to conduct business. So it was unlocked as opposed to being locked here. Plus, the gun in that case was either left out on a shelf or it was out in the open in the back. Here, we've not only got a lock, we've got the crawl space further enclosing keeping it away from other people.
The statute says secured in a locked container. Are you saying? I mean, and it doesn't. It seems to me the statute is assuming it's going to be in a house or in a building, but it's also got to be in a container within that building.
I don't believe that is true. The Presiding case involved, which is cited in Goodrow, I didn't cite it in my brief, but Presiding says considered whether a locked room within a residence could be a locked container. In that particular case, it wasn't, because the lock wasn't a strong enough lock. It could be jiggered open or opened. It was not a secure lock. So that's the distinction there. But a locked container can be a room, as in Presiding, although they decided the lock wasn't secure. And I think it could be a house plus a hidden crawl space. I think that can work. And I think Goodrow helps in that regard. So that's my argument in terms of improper storage. If I could move on to possession with intent to distribute marijuana. I'm suggesting that this is a classic personal use fact pattern. This is a man with a an up-to-date medical marijuana card, growing his own marijuana, smoking it. There was recreational marijuana use. That's personal use. Then the question is, was he intending to use some portion of that for dealing on the side, I think on kind of an amateur type of level? In that regard, there's a couple of statements by...
But if on that point, Mr. Maddox, if the jury believed Ms. Peters, wasn't there clear evidence of an intent to distribute at least to friends and family?
No, Your Honor. First of all, there's a couple of items in her testimony. One is that her actual testimony was, she said, she was asked on volume 2, page 62 and 63, did you ever see Mr. Goodwin sell marijuana? And she said, I wouldn't, I'd say he talked about it amongst his family members, but not specifically selling it in hand with another person. So what she said in that regard was that he talked about it amongst his family members. Then, in closing argument, the prosecutor said on volume 3, page 88, Mr. Goodwin, quote, had been telling her constantly that he was selling marijuana to family and friends, to friends and family. That's what he said. I'd like to point out that the word friends does not appear in the transcript. I did a word search. You can have a law clerk double check me, but the word friends doesn't even appear in the transcript. I think she might have said something like that in an earlier hearing and he misremembered it. I'm not suggesting he's, deliberately misstating the evidence, but her testimony in that regard was that he talked about it, talked about selling. That doesn't say that he admitted to selling. Also,
but isn't that an intent to distribute? Talking about selling?
That's talking about future conduct. I don't think that the intent has to be something in the present. It can't be, I'm thinking about selling in the future, and that's an intent. I don't think that's sufficient. And that's what also with her testimony where he said, I could sell this. He's talking about future conduct, not present day conduct. I could make $3,000 a month. He's discussing the future. He's contemplating, he's kicking it around. I'm suggesting that is insufficient for intent, for possession with intent currently, as that has to be related to current conduct. So I'm suggesting that is a little too, it doesn't quite get there.
Let me ask Justice Kinder and Justice Grant any other questions because your time is up. We'll have to leave it there, Mr. Attorney Maddox. Thank you for your argument. You've raised a lot of issues in your brief.
Thank you, Your Honors.
And we'll read them all.
Thank you very much.
From the Commonwealth.
Good morning. May it please the court. Michelle King, Assistant District Attorney for the Commonwealth. The defendant's convictions for possession of large capacity magazines, possession of a defaced firearm, improper storage of a firearm, and possession with intent to distribute marijuana should all be affirmed.
Can you start where we just left off? Is the future intent good enough?
Yes, it is, Your Honor. As you know, in cases like this, a defendant's intent is often very difficult to ascertain. And so one way that the Commonwealth can prove that is by looking at the defendant's words and his actions. And in this case, the defendant's words and actions are very clear. His actions, if you look at the amount of marijuana that he had in his attic, he had over 40 plants that were actively growing. In addition, he had a large bin of dried marijuana. He had digital scales. He had a number of other items used to cultivate marijuana. But in addition to that, he told Ms. Peters that it was his intent to sell marijuana to people in order to, quote, pay off his wife and to live a different lifestyle. And he claimed that they could make over $3,000, I believe it was, a month in selling marijuana. He advised her not to tell anybody about it because they could get in trouble, and to just sort of keep it on the hush, but that was his intent. So whether he intended to carry out that plan the next day or 2 weeks down the line, that is a clear example of what that marijuana was targeted for. So to answer your question shortly, yes, future intent can be ascertained from the defendant's present words.
Ms. King, I don't want to jump around here too much, but I'd like you to go back to the argument that Mr. Maddox first raised, which was that there was no evidence that the defendant had an opportunity to see or handle the high capacity magazines. Do I recall correctly that there was evidence in the record that these were to be a gift to Mr. Maddox from Ms. Peters? Or am I misremembering that?
I'm sorry, you mean to Mr. Goodwin, Your Honor?
Yes, Mr. Goodwin.
That the magazines were a gift from Ms. Peters to Mr. Goodwin?
I'm asking if there was evidence of that in the record.
I don't recall that evidence, Your Honor. The evidence that I recall is that Ms. Peters testified that she saw the large capacity firearms, the large capacity magazines, not only at Mr. Goodwin's home, but at the place that he worked and she worked with him. And the inference there is that not that Mr. Goodwin's son could have carried the magazines to and from, as Attorney Maddox suggests that those magazines could have been the possession of the defendant's son, but rather the two places where Mr. Goodwin goes, work and home, are the places where those magazines were seen by Ms. Peters. And there was ample testimony from Ms. Peters that she really knew nothing about guns until she became involved with Mr. Goodwin. Mr. Goodwin was heavily involved in guns and fixing them. He had a great deal of knowledge. His uncle testified that he was a gunsmith. Ms. Peters testified about his extensive knowledge, and I would suggest to you that reasonable inference is that those magazines were carried from Mr. Goodwin's home to his place of employment and back to his home, and that it was in fact Mr. Goodwin who must have done that, certainly not Ms. Peters. So that's when viewed in the light most favorable to the Commonwealth, that is circumstantial evidence that Mr. Goodwin possessed those magazines, that he had them in his hand when he was transporting them back and forth. And as Attorney Maddox concedes, those magazines were clearly large capacity. 16 or 18 of them rather were banana style large capacity magazines. The jury had the opportunity to view those magazines. The two magazines that fit into the defaced firearm were stamped with the number 12, which the officer Bonastaro, or Trooper Bonastaro, testified meant that that was the capacity of that particular magazine when it was stamped with a 12. So there was ample circumstantial evidence that Mr. Goodwin had knowledge of the large capacity nature of these magazines.
Can you ask Attorney Maddox didn't know, how did the fact that his client was incarcerated, how did that get to the jury?
I tried searching for that as I was sitting here as well, Your Honor. I do recall the testimony of that, but I don't specifically recall either how that testimony was before the jury. I know they tried not to talk much about it because obviously.
So it seems like it was not included in the search warrant affidavit. So they didn't know at the time that they prepared the affidavit that he was incarcerated.
Correct.
But so you have, still the last information you have is Peters from March 10th, and they don't execute the warrant for another month. So how is that not stale?
Well, Your Honor, unlike drugs and liquor, firearms are durable items that have continuing utility. And In fact, we have direct testimony in this case from the defendant talking about, well, first off, Ms. Peters had observed at least the firearm for 2 years prior, for the 2 years prior. So there is evidence that this is not a new item to the defendant. It was given to him by his uncle. He took the time to have this firearm. It was inoperable when it was given to him. He took the time to order parts for this firearm and to fix it up. And Ms. Peters testified that she saw him test fire it after he fixed it. And there was testimony that Mr. Goodwin said to her, we have this firearm for our protection, and that the thing about this firearm is that it was very important because it could not be traced to him. So if for some reason he fired it, nobody would be able to know that it was his. And those factors are incredibly important to show that this isn't something the defendant had an intent to discard anytime soon. It was continuing utility to him. And that's vitally important in this equation in terms of the staleness of this particular item.
I'm sorry about the jumping around, but can we jump back to the marijuana? You know, now it already, this is 2014, Proposition 2 had already passed. It is decriminalized at this point. It wasn't legal yet. But today, it's legal to have, you know, a marijuana cultivation in your home to a certain extent. What is the line between, you know, and so suppose somebody says, hey man, I can make some money off of this. And then they decide that would be a bad idea because they could get arrested for that. But why is that not this case?
Well, Your Honor, the statute, I mean, again, the statute was obviously enacted after this case, but forgetting that for a moment, the statute's very clear about the number of plants that a person is allowed to possess under the statute. And 40 plants is way over that amount. And the statute is also clear that it's about possession only for personal use and not giving it to someone else, and certainly not selling it to someone else. So this case is far afield of the legislative intent in terms of decriminalizing marijuana.
So you're saying it's not just Ms. Peters' statements, it's the large scale operation that adds further evidence.
Of course, Your Honor, because again, the statute that decriminalizes marijuana in the Commonwealth sets a certain number of plants that each individual or even the household is allowed to possess, and 40 plants is well over that amount. Just with regard to the improper storage argument, in this case, the defendant did have a locked a gun room. It was very clear that he understood that guns, you know, he was a gunsmith. He had an incredible amount of knowledge about guns, and he had a locked gun room, which he could have easily kept his pistol and large capacity magazines within. He chose not to do that. He had his pistol and his large capacity magazines in an area, not in a locked box and not in a locked room. And the statute is very clear with regard to a firearm being in a locked container. And in this case, the fact that they were simply in his house and his house had the ability to be locked does not qualify under the statute. If there are no further questions, I
have a question about the record. I remember seeing somewhere that prior to the search that there was a restraining order and the police took some guns pursuant to that restraining order. Was that in evidence at trial?
I don't believe it was, Your Honor. I believe that was at the motion to suppress.
Okay.
If there are no further questions, I rely on my brief.
Seeing none, thank you both for your arguments, and we'll take it under advisement. Conducted on Zoom and simultaneously live streamed on the Appeals Court YouTube channel. We'll follow the same rules and customs as in the physical courtroom, except you do not have to stand if you don't want to. Once we get going, the clerk will display a countdown clock where the seal is. You'll have 15 minutes to argue. There's no rebuttal. Only one advocate may speak at a time and the others will be muted. But please stay on the video so we can know you're still there. At the same time, please keep reactions and gesticulation to a minimum because we can see you. In addition to being live streamed, the argument is being recorded and will be archived, so it will be available in the future as well. As always, we've read your briefs and we're familiar with the case. And although I'm not going to say this, you're going to need all your time. So, Attorney Shapiro.
Good morning, Your Honors, and may it please the court. My name is Jonathan Shapiro, and I represent the defendant, Michael McCarthy, on his appeal from his conviction of the second-degree murder of Bella Bond. With me is co-counsel Mia Teitelbaum. Mr. McCarthy is entitled to a new trial because the trial judge erroneously instructed the jury that he could be convicted even if they believed that another person, who could only have been Rochelle Bond, was also involved in the crime. The trial judge in this way invited the jury to convict the defendant on a joint venture theory, even though there was no evidence whatsoever to support such a conviction. This instruction invited the jury to return a verdict on the basis of speculation and conjecture, and it deprived defendant of his only defense. Now,
Attorney Shapiro, can I ask you, setting aside for a second that you made the defense very clearly, it was Rochelle or Rachel and not your client. Setting that aside for a second, is just the instruction that the Commonwealth doesn't have to exclude the possibility that someone else is involved. Is that error in every case?
No, and the courts are clear that it is error, however, where the issue is whether it's one or the other of two people. Because in that case, it downgrades the Commonwealth's burden of proof. In this case, it's clear from the very beginning that the Commonwealth tried its case solely on the theory that Michael McCarthy, and only Michael McCarthy, killed Bella Bond by administering a massive blow to her abdomen, and that Rochelle Bond had absolutely nothing to do with the killing. That was clear from the very beginning throughout the entire case. The defendant, on the other hand, contended that he was not even present at the time that Bella Bond died, and that Miss Bond was solely responsible for the death of Bella as a result of neglect, abuse, or even Bella's accidental ingestion of drugs to which Miss Bond was addicted. So in my closing argument, I was on undisputed common ground when, at the beginning of my argument, I told the jury, quote, "The question that will be facing you when you deliberate on a verdict is whether the prosecution has proven beyond a reasonable doubt that Mr. McCarthy, and only Mr. McCarthy, murdered Bella Bond." Given the posture of the case, this was undoubtedly a correct statement of the law.
Counsel, what about the cross-examination of Ms. Bond in which she was asked about her failure to call 911? Could the jury have considered that she was in some way responsible for Bella Bond's death as a result of that?
I think the judge's instruction invited the jury to conclude that, but there was no evidence, and the Commonwealth certainly didn't take the position that that had anything to do with her involvement in the crime at the trial. The Commonwealth was clear that she was charged solely as an accessory after the fact, and the only evidence that supported the charge of being an accessory was the fact that weeks or months after the killing, she misrepresented that Bella was still alive in order to obstruct the investigation. That was the Commonwealth's theory, and that was the only evidence that they produced with respect to Ms. Bond's involvement in the actual killing. So as I say, the law is pretty clear that where a murder can only have been committed by either the defendant or a specific alternate suspect, in order to find beyond a reasonable doubt that the defendant committed the crime, the jury had to conclude that the alternate suspect did not commit it. That's the Farley case, and that's what I told the jury. In Commonwealth versus Salemi, the SJC also held where only two persons could have murdered the victim, and the Commonwealth abandoned a theory of joint venture. The jury could not find the defendant guilty unless they found beyond a reasonable doubt that he and not the other person fired the fatal shots. Indeed, in the Commonwealth's own brief filed in this case, it agrees with my statement in the closing argument when it admits that, and I quote, "The primary issue at trial was whether the Commonwealth proved that the defendant and not Bond caused the death." This is the Commonwealth's acknowledgement that it was one or the other.
What did the Commonwealth say at the time of your argument when they objected, as I recall?
Yeah, they objected, and for the first time during the entire trial, made the claim that defendant could be found guilty as a joint venturer if the jury believed that defendant and Miss Bond murdered Bella together. The trial judge agreed and instructed the jury that my statement had been incorrect, and in her final words to the jury, instructed them that, and I quote, "The Commonwealth does not have the burden of excluding the possibility that one or more other persons were also involved in the case." So she agreed with the Commonwealth that that there could be a finding of guilt based on a joint venture theory. And those were the exact words of the Commonwealth in its argument. In fact, the trial prosecutor argued to the judge that my statement was in error by saying, quote, "I think it would be lawful for the jury to convict defendant as a joint venturer, even though that's not argued. And that's what I'll ask them."
Is the jury limited as a matter of law to consideration of the theory presented to them by the Commonwealth?
They are limited where there's no evidence to support the theory. And there was no evidence introduced by the Commonwealth to support a theory of joint venture. The Commonwealth made that clear at the beginning of the case. It made it clear throughout the case, and it made it clear in its argument to the jury that there was no evidence of a joint venture. And in fact, in the Commonwealth's brief in this court, they admit that there was no evidence of joint venture. The Commonwealth,
except for the one instruction, there's no instruction on joint venture either, though, right? There's no argument that it's okay if she did it, but he shared the state of mind. There's nothing. There's no instruction like that.
no, the Commonwealth did not ask for.
Right. And so the judge says you've got to find beyond a reasonable doubt that the Commonwealth proved all of the elements. And so, and then she instructs on, as murder as a principle. I mean, is there really a chance that with this one, and she only said the thing you're objecting to, she said it once, right? She didn't say it twice.
It was in her final words to the jury.
There was a second time?
Of her instruction, she said that Mr. Shapiro incorrectly
Right.
told you one thing and then went on to say that you can find the defendant guilty without excluding the possibility that others were involved. Now, there were no joint venture instructions. In fact, I had argued that if she was going to present this theory as she did, there had to be.
But just to be clear, I don't believe either the record appendix or the supplemental record appendix includes the requests for instructions by either party. But am I hearing you say that neither party made a written request for a joint venture instruction?
Yes, because as I said, there was no joint venture theory offered by the Commonwealth until it objected to my statement. Now, we say this was error, and last week in our 16L letter, we submitted a case which we believe is virtually in point, and that's Choi versus Commonwealth. In that case, the SJC ruled that it was error for a trial judge to give a similar instruction in an almost identical situation. Now,
but that was an arson case, right? So that included theory of liability under that statute of permitting to be set on fire, or words to that effect.
Right. In Choi, the defendant was charged with arson and murder as a principle. And there was no evidence that her nephew, who had also at one time been a suspect in the case, had set the fatal fire. During jury deliberations, the jury submitted a question asking whether a conviction required a finding that the defendant started the fire herself. And the judge answered no. Now, there were no joint venture instructions in the case. The judge didn't go any further with respect to joint venture. She simply said that the defendant didn't have to start the fire herself. And then on that basis, the SJC concluded that since there was no evidence that anyone other than the defendant set the fire, nor was there any evidence that the defendant participated in a joint venture with her nephew, the judge, and I'm quoting here, the judge's answer to the jury's question invited the jury to convict the defendant under a theory for which there was insufficient evidentiary support and therefore erroneous. Now, similarly, in the present case, even though there was no evidence that anyone other than Mr. McCarthy killed Bella, nor was there any evidence that Mr. McCarthy participated in a joint venture with Ms. Bond, the trial judge invited the jury to convict defendant under a theory for which there was no evidentiary support by suggesting that he could be convicted even if another person who could only have been Ms. Bond was involved in the crime. So there can be no doubt whatsoever that this instruction was highly prejudicial because it deprived the defendant of his only defense, that it was Miss Bond who was solely responsible for Bella's death. Thus, the defendant argued that there was substantial evidence of Miss Bond's involvement alone in Bella's death, and that evidence, the defendant argued, raised a reasonable doubt as to his guilt. However, when the judge instructed the jury that it could convict defendant if they believed that Miss Bond had participated with him in killing Bella, all of the evidence of Miss Bond's involvement, which was used to raise a reasonable doubt as to defendant's guilt, could be used by the jury as additional evidence of defendant's own guilt on a joint venture theory, despite the fact that there was no evidence whatsoever of joint venture in the case. I see that my time has expired, and unless there are any questions, I will yield to the Commonwealth.
Seeing none, thank you, Attorney Shapiro. We'll hear from Attorney Shorey.
Good morning, Your Honors, and may it please the court. Benjamin Shorey on behalf of the Commonwealth. I'll get right into the instruction issue here, and I think there's a bit of a nuance here as to what the instruction did and what the Commonwealth's theory was at trial. The Commonwealth's theory was, from the start to end, that the defendant caused the victim's death when he went into her bedroom and committed a physical assault on her. That never changed. That was the only theory in the closing argument as to how the defendant could be convicted. The instruction the judge gave, I don't think, changed that theory or invited any other theory. I think what it did was say, I mean, the theory continued to be, the evidence before the jury continued to be that the defendant acted as the principal and had the required mens rea and committed the act of causing the victim's death. But whether Rochelle Bond in some way acted or was involved in the murder as well would not negate that evidence. And that's what the instruction presented. The jury didn't have to find beyond a reasonable doubt that Rochelle Bond didn't participate in some way in order to convict the defendant. I think an example might be the jury, if in a case where the Commonwealth presented abundant evidence that a defendant went to someone's home and shot the person without any evidence of a third party's involvement in that, but there was significant question about how the defendant got to the scene and whether someone who drove them to the scene had the same mental state that the defendant had, right? The Commonwealth would not be required to prove that that someone didn't bring the defendant to the scene or that someone else didn't participate in the crime with the required mens rea to commit the crime. That's what the instruction from the judge here clarified to the jury, that they did not have to find beyond a reasonable doubt that Bond wasn't involved in some way in the crime. And so this did not fundamentally change the theory before the jury in any way.
Wasn't the question that was posed to the jury by Mr. Shapiro, or the statement rather, that drew an objection from the Commonwealth? Wasn't Mr. Shapiro's argument up to that point consistent with the Commonwealth's theory?
Well, the exact language was whether the prosecution had proven beyond a reasonable doubt that Mr. McCarthy and only Mr. McCarthy murdered the victim. So the language was murdered, and so that's a little bit fuzzy, only because the jury hadn't, the jury eventually being instructed on murder might have a reasonable doubt as to what Rochelle Bond's involvement was, right? But I think that the judge then stepped back and just said the Commonwealth isn't required to prove the absence of someone else's involvement. So that's a little bit different. whether the bond caused the victim's death by a physical assault, right, might be a little bit different than whether bond was involved in the murder. And I think if defense had said something like the issue is whether the defendant, or whether you have a reasonable doubt about whether Rochelle Bond walked into that room and caused the victim's death, right, that might be a different story, but that wasn't the issue. The issue was whether she was involved in the murder in any capacity, in any way.
Although, I mean, the defense theory, though, is that she was entirely responsible, and then doesn't this instruction at the end invite them to say what Mr. Shapiro said? Well, gosh, maybe maybe he's right about everything that she did, but it doesn't matter.
Well, I don't think from the instructions, if they followed the instructions, they were abundantly clear about what the Commonwealth had to prove as it related to the defendant himself. And there was no question he had to act as a principal in carrying out the attack, and there was no doubt about his mens rea. So I don't think without some sort of joint venture instruction or some type of improper argument from a party that issue was before the jury, simply because the judge clarified this small point. I think the point is legally correct. I mean, we're entirely correct, regardless of the defendant's argument here. Even if that hadn't been made, I don't see any error in the argument or the instruction. I think it's hard to conceive of how it could have been misconstrued by the jury here. If there are no other questions regarding that issue, then I'm glad to rest on my brief.
Well, I have a question. What was the forensic evidence of the cause of death, and was it consistent with Ms. Bond's testimony? It sounds as though the defense is arguing from cases involving things like a gunshot, where there could only be one person who committed the crime, the act. What was the forensic evidence?
So the medical examiner testified to the cause of death being either asphyxiation or dysrhythmia in the heart caused by a sudden blow to the chest. And the evidence, the Bond's testimony was that she saw the defendant strike the victim in the abdomen. The medical evidence also included evidence of other bruises and soft tissue damage to both the abdomen and the back. I know the defendant has contended the medical examiner's testimony is inconsistent with Bond's testimony. I don't think it is, and I think that what the defendant has pointed to is the medical examiner's language in response to cross-examination about the question from defense counsel was, if a 200-pound man punched a 2-year-old child in the stomach with all of his force, would you expect to see internal injuries here that you didn't see? I mean, that's a paraphrase, but essentially what the question was. And the medical examiner acknowledged, I would expect to see internal injuries that weren't present here. I'm not saying it's impossible that this could have happened without that. But the critical point is that the medical examiner there is answering a hypothetical question that isn't the facts of this case. Whether a 200-pound man used all of his force isn't the question, because Rochelle Bond was clear, asked specifically about the force that was used on that punch, and said she couldn't say. So I don't think the testimony contradicted Bond's assessment at all, nor was there the Commonwealth's theory that punch itself was alone the cause of death. That the theory was that the defendant went in and attacked the victim. That part of it that Bond saw was that particular punch. So I really don't think there was any inconsistency there.
I had a question about the DCF records. If Ms. Bond was on trial instead of the defendant, wouldn't the Commonwealth argue that those DCF records establish a pattern of her abusing her children that would be consistent with murdering this child? So wouldn't the, I mean, isn't that the exact argument that the defense is making?
Well, I think that the judge would be well within her discretion in excluding this evidence regardless of who the proponent was. The evidence is very attenuated from what was at issue in the present case. And, I can't see into the mind of another prosecutor had the facts of these cases been different. But I think the judge was correct that the factual allegations in those DCF records were very attenuated from what was alleged in the present case, and that any probative value was exceptionally minimal. I think you can see from the defendant's argument for admission of those records what the real purpose essentially was propensity evidence and nothing more, because what we had in the present case is this physical assault. And what we had there was something just so different in terms of dropping of a baby carriage years earlier. If there's nothing else, I would rest.
I see you.
And we are going live.
Can we hear you? Can we hear you?
Hello. Good morning. Good morning.
And just make it clear. So the DCF and the child are splitting their time 50-50.
Correct.
Okay.
And we are on the record.
Thank you. Good morning and welcome to the Appeals Court oral argument session for November 16, 2020. As you know, the argument is being conducted on Zoom and simultaneously live streamed on our YouTube channel. We will follow the same rules and customs as in the physical courtroom, except you don't have to stand. Each side gets 15 minutes to argue, and as we just mentioned, the appellees will be dividing their time 7.5 minutes each. Once we get going, the session clerk will display a clock on where you see the seal. The attorneys who are not speaking will be muted, but please stay on the video so we can know you're here. And at the same time, please keep reactions to a minimum because we can see you and it can be distracting. In addition to being live streamed, the argument is going to be recorded and archived, so it will be available to be viewed and listened to afterwards. As you know, this is an impounded case or a partially impounded case, so let's use pseudonyms for the players, and I guess here we can refer to the younger child is the one who we're talking about here, but there's also an older child who's in the mother's custody. As always, we've read your briefs and we're familiar with the case, and although you are free to use all your time, you don't have to. There'll be no penalty for finishing early. So with that, Attorney Bernardi for the mother.
Thank you, Your Honor.
I'm sorry. I've got to call the case, which is 2020 P130, Department of Children and Families versus Mother.
Thank you, Your Honor. Good morning, Justice Massing, Justice Kinder, and Justice Grant. If it please the court, my name is Christine Bernardi, and I am counsel for Mother in this matter. Unfitness is reserved for parenting that is so bad, so lacking that a child's health and safety are in such jeopardy that the child is in serious danger. That is not the case here. Therefore, the trial court's judgment must be vacated and her subsidiary findings together do not prove Mother is unfit clearly and convincingly. At the time of trial, the child was 5 years old. He visited with his mother every weekend and had done so since April of 2018. A total of more than 50 weekend visits. The court found that since April of 2018, there had been no concerns about the child's well-being while in mother's care. That is in the judge's conclusion of law number 29. Mother and or the children were working with no less than 15 collaterals in her home, in the foster parents' home, in the schools, and in the community. And no one raised any concerns about the younger child's safety, health, or welfare before, during, or after these visits. As you are aware, there were two.
Bernardi, can I ask you that
Yes?
there does seem to be one person who raises concerns about the mother's ability to parent both children at the time, and that is the mother herself. There's parts in the record where she says, I'm not ready to take the younger child with the older child. And it seems that towards the end of the case, the judge reopens the case, there's a footnote. And when they're doing it, the DCF is planning to prepare to return the child to the mother, and she still says, I'm still not ready.
She didn't say she wasn't ready, Your Honor. Let me back that up. In 2017, she says she's not ready. In 2019, she says she's ready. In October of 2019, which is after the evidence is closed, Your Honor, if Your Honor is asking me to address that, even though it's not part of this record.
Although it is part of the record, it's marked as an exhibit. The judge says she reopened the hearing and it was marked as an exhibit, and we have it as an exhibit.
It's actually a footnote in her findings, Your Honor, which her findings she submitted in January of 2019. But that footnote, mother was ready, but she did not want the child to be taken out of school during that time. She wanted the child to finish the school year, Your Honor. It's a footnote, but it doesn't finish everything that mother had said. Mother was ready and willing to take her child, but as a good parent who wanted to see her child finish the school year where he'd been, she was not saying she wasn't ready. She was saying she felt that it was in her child's best interest to remain in the foster home until the end of the school year, which was June of 2020.
So how do you, and maybe I have to ask this of DCF, but how do you work that? Does the mother doesn't want the child to be in her custody, but you return custody to her? So how does that work?
Well, Your Honor, at that time, we don't have the evidence before us. It's not in the record as to what was happening with the child at that time, Your Honor. You're talking from the period of June 2019, after the close of evidence, and January of 2019, when the judge issues her findings. We do not have that evidence before the court, Your Honor. However, stating for a parent to say that they do not want to disrupt a child does not make them unfit. It makes them actually a good parent, making a determination that right now it is better for my son to be where he is. Saying that a child is not ready to come out of the hospital because they still need care, or a child isn't ready to come out of a residential because they still need care, does not make a person a bad parent. It makes the person making a good logical decision on behalf of their children.
What do you have to say about Ms. Henderson's view that the mother wasn't ready to take care of both children at once?
Okay, so Ms. Henderson, she observed the mother for 2 hours. And that, I want to make that perfectly clear. It was 2 hours, 2 weeks before, not even 2 weeks before trial, after the child had been in in Dominican Republic for 2 weeks with his foster parent. Mother had only seen the child once since that time, and then there was this visit. That is clearly in the record. Now, Ms. Henderson is really a neophyte. She had barely any experience at all. She was not qualified as a parenting evaluator, which is what she was actually appointed to do. She was qualified as a family assessor. She gave conflicting evidence about whether or not mother set limits or didn't set limits during the course of her testimony. And she really didn't have the experience and knowledge to make the determination that she made. Your Honor, we have Ms. Frank, who had spent hours upon hours. She spent from August of 2018 through June of 2019, a master's degree clinician who had worked every week with mother and the older child in the home, who stated that the skills that she had worked with mother on for the older child were generalized skills that were transferable over to her parenting of the younger child. That is Ms. Frank, again, master's degree in social work, licensed clinical social worker, 10 years experience with Justice Resource Institute, working with families for 10 years. Ms. Henderson had just started at the court clinic, had not done a previous evaluation for parenting evaluations. This was her first actually written report that she'd ever done for the court. And she had observed the parent and the children for 2 hours, one time. And Ms. Frank had worked with the family from August of 2018 to June of 2019. Further, Ms. Cody, or Ms. Coate, Beth Coate, an intensive care coordinator, had also worked with mother and the children. She worked with mother and the child from, my memory is, I believe it was September of 2018 through March of 2019. She worked with mother on parenting skills in terms of setting calendars, making appointments, making sure the children's needs are met. And she completed her services in March of 2019, stating that mother had met all the goals of those services. Then we also have a family partner who worked with mother, who also stated that she had met all the goals of that service. So all of these services were in place and mother met all the goals, and we're talking 80+ hours that these folks did in person work with mother and the older child, 80+ hours. And we have one person who visited and observed one visit for 2 hours, making that determination. It doesn't add up. It doesn't match. So as I stated, mother and the children worked with no less than 15 collaterals during the course of this case. As you are aware, there were 2 children subject to this petition. The older child was dismissed on a motion by mother's counsel. He'd been returned to the care of his mother in April of 2018. DCF knew he had been sexually abused when they returned him, and they did not inform mother that he had been sexually abused in the foster home. He had significant behavioral issues when he was returned home. It wasn't until there was a question of inappropriate behavior between the 2 children in July of 2018 that mother was actually informed that her eldest child had been abused while in foster care. Why is this important to my argument? Because he's not subject to this petition? Well, it's because mother worked with numerous providers to stabilize her older son after this traumatic event, while dealing with her own feelings, her own trauma of learning of this information, and her own guilt. During this time, DCF continued overnight weekend visits with the younger child. Again, not one collateral, and there were many, including DCF, raised any concerns for mother's parenting of either child during this very traumatic time, and there had been consistently weekend overnight visits with mother and her 2 sons. Also, mother maintained her sobriety and her mental health stability during this entire traumatic time. Mother made all her appointments with the clinicians assigned to her. During the length of this case, DCF did not modify mother's service plan from July of 2017, which is the start of this case, through the time of trial. Mother completed every service that DCF requested of her on her service plan, and even services not requested of her. And she evolved and learned from these services, improving her relationship with each of her sons. Her parenting was much improved. And in spite of her compliance, progress, and success, DCF continued to request mother participate in the same services over and over again. Mother completed 2 rounds of substance abuse treatment and did not participate in further programs. The court called that disengagement. They called it withdrawn. Actually, the evidence presented was that she didn't need any further programs. There was no evidence that her sobriety was fragile or unstable.
Question, counsel, I have a question. What do you have to say about the judge's finding that the mother wasn't equipped to deal with the younger child's sleep disorders?
The sleep disorder seems to be something that the judge really hangs her hat on. There's nothing, the evidence is that the only evidence presented was that the child had difficulty sometimes sleeping and sometimes had nightmares. And the sleep plan, quote unquote, that was presented was that he couldn't have electronic devices for a certain period of time before bed, and some other modifications which were never put in evidence. We have no idea what those other modifications were, but let's go back to the child had had overnight visits since November of 2017 with his mother, one overnight each weekend from November 2017 till March 2018. Then starting in March 2018 through the time of trial in June of 2019, the child had overnight weekends from Friday to Sunday. There were no issues raised by anyone that the child was tired, was having any problems in school on Monday morning. There was no evidence presented that there were any concerns. And as a matter of fact, to go back to the finding of the judge, the conclusion of law number 21, I think it was, where the judge says, 29, where the judge says there's been no concerns about the child's well-being in mother's care. That was one of her conclusions of law. It just seems like a red herring that they just throw up, they don't have enough evidence for something. So we create this exaggeration of the sleep problem And there's no plan beyond no electronic devices. And mother actually testified that she knew about the no electronic devices and she was implementing that. The younger child also, there's talk about him having special needs. Over and over throughout the record, in both the DCF letters to the court and the testimony of the various witnesses, was that the child they didn't have any special needs. He was a nice, talkative, sweet child who was very social, who was academically up to date, who was socially up to date. There were no concerns about him. So when we say that he has special needs or he has special attention needed for him, there's nothing in the record as to what that special attention was, except for when Ms. Henderson is asked by the DCF attorney, what is the ideal place for this child to live? What is the ideal? That is not what this court is looking at. This court the requirement is adequate parenting, minimally adequate parenting. And there's nothing in the record that shows that mother cannot meet that. As a matter of fact, mother has shown far beyond that she can adequately parent this child and both children together through those, again, 50 overnight weekend visits from March of 2018 through June of 2019.
So I'm sorry, I'm still stuck on my first question and we asked it a different way. So is the judge, by the finding of unfitness, gave the department permanent custody?
Yes.
Are you saying that the judge should have not found unfitness and given the department continued temporary custody?
No, the department, the judge should have found mother fit and should have returned the child to mother at that time. In June of 2019, mother was ready to take the child home, and that is stated actually in Mr. Hoffman's Mr. Hoffman's closing argument. He states that mother is ready, willing, and able to take the child home that day. Things change because he's now back in school. June 2019, the school year is ending. October 2019, there's a whole new school year. He started a new school. He's in a new, she doesn't want to disrupt him at that time, Your Honor. Okay. The court gave significant weight to the two-hour parenting observation of Ms. Henderson, which was gravely exaggerated. Most notably, Ms. Frank who provided trauma-informed treatment for mother and older son for 9 months, met with them approximately 40 times for 2 hours in mother's home, testified that mother learned all the skills necessary for her to parent in a generalized way for both children. The judge's subsidiary findings do not support the court's ultimate conclusion that mother has grievous shortcomings resulting in much hazard to her youngest son. There was little to no evidence presented to the court that the child's welfare would be subject to substantial harm if returned to his mother, and therefore this court should vacate the lower court's decision. Thank you, Your Honor.
Thank you. Okay, we're gonna hear from the DCF first or the child first? Raise your hand here. Who's going first? Okay.
Good morning, Your Honors. Attorney Carrie Kip Horseman on behalf of the Department of Children and Families. In this care and protection case that does not involve termination of mother's parental rights, there was clear and convincing evidence of mother's current parental unfitness in, first, mother's statements and her behavior around the issue of her being overwhelmed and unable to meet the needs of both of her youngest children. And second, her current unfitness is also demonstrated by her current lack of engagement in any substance abuse treatment, despite her 23-year history of substance abuse disorder, despite having multiple children being born with cocaine in their system. And despite this case coming into being as a result of mother relapsing on cocaine while both children were in her care. First, as Justice Massing alluded to, mother did make statements about feeling overwhelmed and feeling unready to care for both of her children. Back in May of 2017, she said that the younger child required a lot from her, and she wished that his godmother would continue to care for him until he was older. She said this again in December of 2017, and most significantly in October of 2019, when the department proposed a plan whereby the younger child would be transitioned to mother's care on a full-time basis by December of that year. She declined that proposal for reunification.
Although, isn't Attorney Bernardi right? Shouldn't we stop the clock at the end of the trial before there's changed circumstances?
Normally, yes, and the department would very much be advocating that the clock does stop at the time of trial. But in this case, Judge Craven reopened the hearing, and she took evidence as to what had happened since that time. If you look in Record Appendix pages 204 to 207, the judge considered evidence about what the department had been doing and had been offering to the mother since the time of trial in June of 2019, and specifically took evidence in regard to the transition plan. So it's an unusual circumstance in this case, but the judge, in her discretion, reopened that piece of the evidence. More significant than mother's statements about, her candid statements about feeling overwhelmed is mother's behavior that demonstrated her being overwhelmed and unable to handle both of the children. The last time both of the children were in her care, she took them both to a party, ingested cocaine, came home and was intoxicated and slurring and unstable, and ended up with police involvement and being psychiatrically hospitalized. Also, she has been demonstrated that she's overwhelmed, often even with the care of her older son. He missed at least 56 days of school one year, causing him to repeat first grade. And even more currently, in the 6 months prior to the trial in 2019, the older child had missed 16 days of school, at least 10 of which were unexcused. So her behavior also demonstrates her being overwhelmed. In addition, the 2-hour visit, the most recent visit prior to trial, mother again displayed erratic and unstable, I think the quote was bizarre behavior during the visit, and she was unable, even in that 2-hour period, to adequately supervise either one of her children. The older child being, locked in his room despite his history of mental health issues and playing an inappropriate video game involving violence. And then the younger child was found unsupervised at the top of a precarious set of stairs. And this was in, just a week or two before the trial started. And it was certainly within the judge's discretion to decide what evidence to weigh more heavily. The judge in this case did not ignore the favorable evidence in regard to mother, but she, in her discretion, weighed the evidence that was more recent and provided by an expert in family assessments, the court clinician, Ms. Henderson. And it was the court's discretion to decide which evidence to weigh more heavily, so long as the judge demonstrated that she paid careful attention to the evidence, which she did in this case. She made 145 findings and conclusions of law. So this court, as is very well aware, is to give great deference to the trial judge who observed the credibility and the demeanor of the witnesses.
It's a very unusual case, though, right? And I've never seen such ambivalent findings. The judge really does credit the mother with a lot of accomplishments, with completing programs. She finds that DCF didn't provide adequate services, yet nonetheless ends up on the side of saying that the mother's unfit.
She does, but she orders a reunification plan. The department's goal at that time, and even after the trial, was reunification. So it is unusual to have a case. I think that I'm certainly used to arguing before the court in terms of termination cases, and this is not that. This is a case where the department's plan was reunification, and the judge ordered that to begin post haste. And in fact, it was happening prior to the mother deciding that waiting would be a better way to go in this case.
You know, it's really frustrating as it being, you know, the court in this case. We're dealing with events that happened a year ago. Would really, you know, really love to know what's going on today, but I can see in a case like this, actually, that could be very prejudicial either way. So I mean, it's a good thing we don't know it, but we are in kind of an artificial.
Yeah. I understand that it is unusual in that sense, but I would just, again, remind the court, this is a care and protection case, not involving the termination of mother's parental rights. And if there are no other questions, the department would cede the rest of the time to the child's attorney and respectfully ask that this court affirm the trial court's careful, thoughtful decision. Thank you.
Thank you.
Good morning. May it please the court, Sharon Sullivan Puccini on behalf of the minor child, and I'll refer to him as JV. He's a 6-year-old boy in 1st grade, and his position is consistent that he would like to stay living with his foster family. And I urge this court to look at, or to listen and look at mother's words, her specific words. She's not ready. She said this before, it's a pattern. Now, at the court, in the court document, in the findings specifically, it says that mother preferred that JV be returned in June of 2020 when school is out. But if you look at Exhibit 46, which is the report from DCF, it states that mother told the DCF social worker, quote, after long deliberation within herself, and that would be what DCF said, she was, quote, fearful that if she takes JV now, he will resent her and have a difficult transition with her. She also reported that not having a car would be difficult for her, and she did not want JV to, quote, develop behaviors because he was uprooted from his foster family too soon. Now, if you look after the trial,
but again, though, what if the different decision had been made in June, none of this would have happened?
Well, there was unfitness in June. It's what the DCF attorney just argued. Right. She wasn't fit because in June, hey, I'm ready to take him. She wasn't. If you look specifically at what was going on in the 6 months before and through trial, not engaged in services for treatment, not doing tox screens. Actually, I think Dr. Baker, who's her therapist for a number of years, said that she wasn't going to appointments despite her having, if you look at the transcript, she can't remember when her last appointment was. She runs out in the hall, gets her phone, and she's still not sure. The judge didn't credit her testimony at that point and specifically says she wasn't going to her therapy. If you look in June, and if you look in January of 2019, Dr. Baker was concerned again that she was stressed, and he was telling her to reach out to him, and she wasn't doing that when she was stressed. Mother's stress, what does that have to do with all of this and her unfitness? Well, what happened in July of 2017 when the children were removed, she had been using substance abuse. She was abusing substances and ended up being hospitalized. And why is that important? Because at that time, what did she say to the DCF workers? Quote, she did not feel ready to care for JV. And at that point, she no longer wanted to care for either child, and she couldn't handle life anymore. And if I back up to May of 2017, just 2 months before the incident with the 51A is filed, that's when she said she was not ready to care for JV, who had spent most of his time with foster mother. And I just want to point out, at that point, JV had been with foster mom since birth. He's returned to his mom in August of 2016. So fast forward to May of 2017, she's saying these statements. She wishes godmother could take care of him until he's older. He was too young and required a lot from her, and he was too attached to her. And I would suggest if, little children, little problems, just wait till he's a teenager and she wants to take him back then. There's going to be a lot of problems dealing with the behaviors and just everything that goes around with caring for two children. I also want to point out in relation to Mom's argument about Ms. Henderson. She takes issue with her, but Ms. Henderson not only just watched that visit for 2 hours, she met with Mother 3 times, only 1 time with her attorney. She also spoke to collaterals, including Dr. Baker. And she did have experience and knowledge. This may have been her first case that she wrote up, but I think you can use common sense as a parent or as an adult to say that dealing with 2 children at the same time is not like having 1 child, especially one with needs of what Jay had. And I would say that, you know, what are the special needs of JV? He does have unique needs, and it did include his sleep problem. At the time of trial in June of 2019, he was still having nightmares. And if you look at the testimony, it was when was the nightmares? It would be Thursday night and Sunday night, before and after Mother visits. Also, I think the bond that he has with his foster family is something that's it's in there, but it's being overlooked, because that transition and getting him to be severed from his foster family that he has been with his whole life, that's going to cause some problems. And to think on the day of trial, when she's still showing unfitness, that judge was going to say, here you go, you can have your son back, when you have another son who granted Mother did do a lot of work with her, and the judge did specifically find that she had made progress with Jay, but JV added to the program was gonna be a lot for her. And those people in the house had not even worked with JV. And going back to that visit, that 2-hour visit, something that was in the transcript that the judge didn't specifically find, but it's undisputed, in which Henderson is basing some of her decision on, is that she viewed that the Mother was short with Jay at that time. And she says, well, it was difficult to be in there for 2 hours with him, with both children being observed, but the Ms. Henderson said, you know, this is your time to shine. And she made a comment to them about, well, usually I would have a hotspot on, or they wouldn't be in my face with me. So just even those comments show that she's not ready. She would need the tools to be able to parent both children at the same time. And I think
ask a question about the reunification plan. Did the reunification plan continue the weekend visits?
The specific reunification plan was he was supposed to be returned in December,
right,
with the weekend visits and him transferring schools at that time. That was part of the plan that all the parties had worked on.
Okay, and the parties and the child agreed with that plan at the time.
Yes, that was the plan. But that was I could say that, but then his position, as his attorney, I advocate for what he wants, and his position is to stay at that time, even at that time, but to stay with his foster family. It's in his best interest to stay with his foster family. And that's what he would like.
All right.
If there's no further questions, I'll rest on my brief.
Seeing none, no, thank you. Thank you all. Tough case, well argued.
We're going live. And on the record.
Thank you. Good morning and welcome to the Appeals Court oral argument session for November 16, 2020. As you know, this argument is being conducted on Zoom and simultaneously live streamed on the Appeals Court YouTube channel. We'll follow the same rules and customs as in the physical courtroom, except you don't have to stand. Each side gets 15 minutes. There's no rebuttal. Only one advocate will speak at a time. The other will be muted, but be mindful that we can still see you. So please keep reactions to a minimum, as that can be distracting. This is, as you know, an impounded case, so we'll refer to the petitioner as Mr. Coe. And as always, we've read your briefs and we're familiar with the case. And although you're free to use all 15 minutes, there's no penalty for stopping early. And with that, we'll turn to Attorney Hinton representing Mr. Coe.
Good morning, Your Honors. May it please the court. Plaintiff in this case challenges the SORB's denial of relief from registration and the decision to classify him as a level 1 on grounds that the board failed to prove by clear and convincing evidence that he posed a low risk of reoffense, and that the SORB arbitrarily rejected without a proper basis and refused to apply compelling updated scientific research presented through expert testimony and through the published scientific research of Dr. R. Carl Hansen, who is the board's own foremost authority, cited throughout the regulations and recognized by the SJC to be the major authority upon which the guidelines are based.
I'm sorry, Attorney Hinton, I'm going to interrupt just for a second because I didn't call the case, which is 19P1104, code number 5481 versus Sex Offender Registry. I apologize for interrupting.
No problem. So as I was saying, the SORB arbitrarily rejected without a proper basis this research that demonstrates that after 20 years of offense-free time in the community, the plaintiff posed no cognizable risk. Now, at the time of the SORB's January 2018 classification decision, this then 73-year-old petitioner, who was convicted in 1997 of non-penetrative offenses involving a foster child and a step-granddaughter occurring back in 1994 and 1996. He had completed probation, he had completed sex offender treatment, he had completed alcohol treatment, he had achieved full sobriety by 2001, corroborated by his former police officer's landlord and social worker neighbor. He had expressed extreme remorse, and he had been living offense-free in the community, working steadily, living in the same apartment for more than 20 years. Now, in order to make such a petitioner a level 1, the board had to prove by clear and convincing evidence that he posed a cognizable risk. So this is the language of LL versus Commonwealth, 470 Mass 169. A low risk means a risk that is cognizable, perceptible, capable of being known, perceived, apprehended, articulated based on the affirmative evidence. It doesn't mean a hypothetical or speculative risk. It doesn't mean anything more than no. If the board can't prove that, then he can't be required to register under DO 24341. And Commonwealth v. Hammond stated that an as-applied due process challenge could be made to the requirement to register. And that's what has been done here. So
as I'm reading through your brief and listening to your argument, the question that comes to my mind, aren't you arguing based on this new evidence that basically anybody who's offense-free for 20 years is a zero?
Well, there are some charts, and it takes different periods of time depending on where one starts.
But you argue that your client it takes 3 years because he was a -1. The highest one's going to take 20 years. So anybody after 20 years.
Yeah. Now the board has pointed out there might be some hypothetical extreme high risk offender with a static 99R score between 7 and 12, that's as high as it goes, where there wasn't sufficient data for the research to cover such a person. That is an extreme hypothetical, and that's not the situation here. I mean, this is someone who had a -1 static 99R score at the outset. It would have taken him 3 years to get to non-cognizable risk. I mean,
I kind of hear you saying yes, that as a matter of law, anybody should be relieved from registration after 20 years.
Well, it's not quite as simple as like a blanket assertion. It's scientific. The issue of what counts as cognizable risk, it's scientifically knowable, it's calculable, it's based on actual research, it's based on complex statistical regression analysis involving thousands of actual sex offenders. There were 20 data sets, there were 7,400 something individuals in the study that Dr. Hansen published after the SORB's regulations were promulgated in 2016. And I've put some of the charts, at least 2 of the charts, I've embedded them in the brief so that you can see them quickly, get to them quickly. And it, depending on where one starts over time, and by the end of a 20-year period, the vast majority, except for a possibility of some extreme hypothetical, crazily super predator type person where there's not enough data, everybody else is going to, by 20 years, is going to, their risk level is going to decline each year. And it turns out that the risk level, that the level of decline based on offense-free time is something like 6 times greater than the level of decline just based on growing older. So there's a very...
Ms. Hinton, I know the SJC has talked about the importance of the regulatory framework applied in these cases being up to date with current scientific standards and research. Weren't the regulatory factors changed relatively recent to when the decision in this case was made?
Yeah, the regulatory factors were changed in 2016. And this factor 29 was based on research by Dr. Hansen that was done in 2014. Subsequently, in 2018, the 2014 article that the SORB factor relies on said further research needs to be done. Subsequently, in 2018, that further research was developed by Dr. Hansen.
But doesn't the hearing examiner have an obligation as part of his job to apply the regulatory factors that are in place at the time?
Yes, but under DO 205614, the SORB hearing examiner also has the duty to consider other useful information and to respond in a flexible manner to authoritative research as it is published. And there's some very strong language in DO 205614, and that includes up-to-date research on the potency of existing risk factors. So not just some risk factor or some factor that's never been considered before by anybody, but the potency of the existing risk factors. The SORB has a duty to keep up to date on authoritative research. That doesn't mean any old article that's published, but this is Dr. Hansen. I mean, Dr. Hansen is the purported basis for 19 out of the 38 of SORB's factors. He's the guy that they're citing, and he's the guy that they're citing for this factor 29. So the SORB seems to be saying, we don't have to look at updated research by Dr. Hansen that came after our regulatory guideline. We're just going to rely on his old research. And that doesn't make any sense. That does not comport with DO 205614, the duty to keep up to date on authoritative research.
But this isn't really a case where the hearing examiner just rejected in wholesale fashion your client's expert or the scientific data. He commented on it and then rejected it for reasons that he articulated in his decision regarding application of the factors, right?
Respectfully, I disagree. He basically said, I don't have to listen to this expert's opinion, and I can do it any way I want. That's not a reasoned basis. And
I take it you're not quoting there.
The only explicit he gave, I'm sorry.
I said I don't recall reading that particular phrase in the hearing exam.
Well, he said the doctor and I disagree. I mean, that's not an explicit reason. The only thing that could arguably be considered an explicit reason is a difference of opinion about factor 2. And in my reply brief, I talked at length about that. He weighed heavily factor 2, the repetitive and compulsive factor. And this is a case in which there was no confrontation, no charge, nobody there was nothing between the two episodes. And so, under recent case, and there was also nothing to show compulsion. And so under recent case law, DO 22188 out of the appeals court and an unpublished decision, DO 524454, which I believe Justice Kinder participated in yourself, where there's no finding, where there's a finding of repetition but no compulsion, that was error. And where weighing factor 2 heavily, even though there was no confrontation, apprehension, or charge in between two episodes, is an error. So I don't see how that, which was the only explicit, arguably explicit basis for rejecting Dr. Guidry's opinion and for refusing to consider the updated authoritative research, I don't see how an erroneous finding could qualify as a reasoned basis to reject the expert opinion. So I don't think that could count. I mean, other than that, all he said was that basically that the expert used a different means for assessing risk, but he was required to consider expert opinion, and he's required, if he's going to reject uncontradicted expert opinion, he has to have a reasoned basis, and there's no reasoned basis here. I mean, the idea that Dr. Guidry's evidence-based best practice method is to be rejected because it is an evidence-based best practice method, that does not make sense. I mean, the scientific research, this is a knowable, detectable, quantifiable level of risk, where someone who has an ordinary static 99 R score after 20 years is no more risky than a non-sexual offender. If we're going to treat sexual offenders differently from non-sexual offenders, there has to be a perceptible basis for doing so. And
couldn't the perceptible basis that the hearing examiner found be based in part on the facts of the crimes involving two different child victims some time apart, where the co was alleged to have gone into their bedrooms at night? Doesn't that show a certain level of compulsion?
No, there was no evidence about compulsion. At that time, he had an alcohol problem. He later had treatment, and he later became completely sober for 17 years. The static 99R is research that's empirically based, and it can't be tossed out based on nothing. I mean, as Judge Wilkins, who looked at this case, he agreed that there was no scientific basis for rejecting this opinion. He basically, there's where this offender, after 20 years and after aging, he's now 76. He was 73 at the time of hearing. The risk doesn't remain static. It doesn't just stay one level of risk over all that period of time. It's consistently going down, 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 down. And to the point that he's no more risky than a non-sexual offender spontaneously committing a first-time sexual offense out of the blue. And just because the facts are, unpleasant doesn't change that.
Why didn't Justice Wilkins reverse this then?
Because he felt he was, at that point, he felt that he was constrained. That was 5 months before DO 23656, the SJC decision that said the board has to explain on the record explicitly, objectively adequate reasons to reject uncontradicted expert testimony. Judge Wilkins did not have the benefit of that decision before him. And this court now does have the benefit of that decision. In a case where there's an ongoing pending appeal, the plaintiff gets the benefit of that decision. That case also said where an expert's testimony spoke to some but not all of the relevant considerations, that's not an objectively adequate reason to reject the testimony. So
here's what the hearing examiner said about Dr. Guidry's testimony. To the extent that Dr. Guidry used actuarial and self-reported psychological testing to arrive at the conclusions, I reject the process Dr. Guidry employed in lieu of assessment based on the board's regulatory factors. So there was an explanation. Your argument, I take it, is that's inadequate.
It's inadequate because DOE 205614 compels the SORB to consider authoritative, updated research that was issued after the regulations. And that is what was not done in this case.
Thank you.
If there are no further questions.
Thank you very much. We'll hear from the board.
Good morning, Your Honors. May it please the court, Rachel Machad for the board. So the board's position is that the hearing examiner's decision is supported by substantial evidence. There were two high-risk factors present in this case, factor 2, which is repetitive and compulsive. And just to address that briefly, the hearing examiner found that it applied with a threshold weight in that the offender offended against an 8 or 9-year-old victim in 1994, and then 2 years later in 1996, offended against his 10-year-old foster daughter. The board's regulations define, well, first repetitive because it happened in 1994 and 1996, but then in looking at compulsion, the board's regulatory factors defines that as time and opportunity to reflect on the wrongfulness of one's conduct. And here, certainly, the hearing examiner, I think, was justified in finding that 2 years was sufficient time and opportunity to reflect on the wrongfulness of that conduct before reoffense. In addition to those two high-risk factors, there were several risk-elevating factors and considerable risk-mitigating factors in this case. The hearing examiner explained the evidence that he relied on in determining the weight of each factor. And ultimately, he arrived at the determination that Mr. Doe now poses a low risk to reoffend. I would say that he paid careful attention to the risk mitigating factors in this case. And although it was a de novo hearing, he was preliminarily classified as a level 2 offender. And then after the hearing, he was determined to be the low risk. That includes no public access to his information, and his registration information is only available to law enforcement agencies and child protection agencies. Regarding factor 29, which is the offense-free time in the community, the hearing examiner applied factor 29 with full weight. Doe essentially takes issue with this factor not being dispositive, but factor 29 is but one of many factors. The only research article submitted that postdated the board's regulations was that Hansen and Harris article. And the hearing examiner in factor 37, other useful information, specifically articulated that he considered the articles submitted by the offender, but he found that they were adequately covered by the present factors, in this case, factor 29. This case is not like Doe 151564, which is the age case. At the time of that case, the board's factors were completely silent on the impact of advanced age on recidivism. And this matter is unlike Doe 205614, which is the gender case. At that time, the board's regulations were also completely silent on the recidivism impact of a female offender, in that the board's regulations were all normed around male offenders, and even the pronouns were for male offenders. But so the article submitted by Doe utilizes the static 99R scores. The static 99R contains 10 items of demographic and criminal history information. It is limited in what it considers, and that was also confirmed by Dr. Guidry, who testified that it can't take into account everything. So here, the hearing examiner applied factor 29 with substantial weight, with full weight. Factor 29 reads, the likelihood of sexual recidivism decreases the longer the sex offender has access to the community without committing any new sex offenses. And when board counsel asked Dr. Guidry on cross-examination at the hearing if she thought that the board's regulations considered the desistance factor regarding offense-free time in the community, she testified, I think so, but I'm not sure in this sort of calculated way that we have now, but the data tells us there's a 12% decrease each year. And That is something that Mr. Doe got the benefit of, but again, it was but one of many factors. So he got the benefit of full weight being assigned to factor 29, which is offense-free time in the community. But the static 99R, that's not, it does not determine individualized risk, which is why the hearing examiner opted for a holistic review of the board's regulatory factors.
Can I ask you a question about 205614?
Yes.
You distinguished it because there was no gender at that point, and the regs didn't even consider that. But Ms. Hinton argued that it also says that the board has to rely on up-to-date research on the potency of existing factors. Is that not in the case?
That's also in the case, yes. But here, I think that the article submitted is also already covered by factor 29. And again, the hearing examiner applied factor 29 in this case with full weight. The only difference between him, I think, applying the substantial mitigation for factor 29 and what Co is trying to say is it's not dispositive in this case. It again is but one of many factors.
Can I ask a question about 178K2D? I mean, the thing about as a matter of law, most people don't have to register after 15 or 20 years, right? What is it? Except you can't relieve somebody who's had a violent offense or a offense against children, right? Is that the...
Correct. Although, I mean, there's two pathways to relief. One is the statutory pathway, and then one is based on constitutional grounds. So here, despite his offenses, had the hearing examiner found that Mr. Doe poses no cognizable risk to reoffend, he would have a constitutional pathway to relief, certainly.
And is the board now taking a position that it can give that relief, or are they still saying only a judge can give that relief?
So there are, I believe my sister included it in the addendum of her brief. There are declaratories in superior courts where the court found that we do have the authority to do so, and we have been exercising that authority, yes.
Okay, so that's Judge Gordon's opinion. That's the governing document at the moment.
Yeah, there's a few declaratories, Justice Gordon and Judge Wilkins as well. And so just to briefly address the expert testimony in this case, Dr. Guidry opined that Doe poses no cognizable risk to reoffend. Doe 23656 reaffirms that Doe is not entitled to a guarantee that SOR will reach the same conclusion as his expert. He's entitled only to careful consideration of his expert's testimony. In this case, he did carefully consider Dr. Guidry's testimony. He dedicated approximately 3 pages of, reviewing her testimony and then articulating where he parted ways with her. Significantly, he relied on the high-risk factors and risk-elevating factors present in this case. I know that there was an issue. Dr. Guidry didn't apply factor 2 in this case because she didn't consider it as he was not detected or sanctioned for his offense between offending. That's not how the board's factor 2 works. It does plainly apply in this matter. And the board's position is that was sufficient reason for the hearing examiner to part ways with Dr. Guidry's opinion. But even more so than that, there's no indication that Dr. Guidry considered the victims' ages, which here, factor 3 considers that in with increased weight. And if no questions, the board will rest on its brief.
None. Okay. Thank you. Each side gets 15 minutes. There's no rebuttal. And we will silence the party who's not speaking. But please stay on the video so we can make sure you're here. But at the same token, remember that we can see you, so keep reactions to a minimum because that can be distracting. In addition to being live streamed, the argument is being recorded and archived, so it'll be available for viewing later. And as always, we have read your briefs and we're familiar with your case. And although you're free to use all 15 minutes, we don't hold it against you if you finish early. With that, I'll call the case, which is Peterborough Housing Associates LP versus JUAN Garnier. You can tell me how to pronounce it, 20P915. And we're hearing argument today from a student practitioner in his 3rd year of law school. Welcome, Mr. Ajogo?
Ojo.
And the floor is yours.
Thank you. Thank you. Good afternoon, Your Honor. My name is Dennis Ojo, and I'm SJC Rule 303 counsel here on behalf of Mr. Juan Garnier. May it please the court. This is a civil case that began with concerns about harassing emails and that ended with the civil contempt remedy that was impossible for Mr. Garnier to cure, and with an indefinite vacate order that is masquerading as a preliminary injunction. This civil case previously resolved in 2 agreements. When Mr. Garnier was alleged to have violated those agreements, the landlord improperly sought to evict Mr. Garnier within this civil case. The landlord did not start a summary process case, which was the plaintiff's plain, adequate, and complete remedy at law. Nevertheless, the housing court judge found Mr. Garnier in contempt of the civil agreement and ordered Mr. Garnier to vacate his home indefinitely. Mr. Garnier was, for all intents and purposes, ordered evicted by the housing court as a remedy for civil contempt and as injunctive relief in violation of Mr. Garnier's constitutional and statutory rights to a jury trial. The legislature has carefully considered circumstances such as those in this case, and it is well established in the Massachusetts Constitution, statutes, and case law that tenants, especially those who are subsidized and cannot afford housing in the private market, are not to lose their home without the robust procedural protections that attach to the statutory remedies, namely summary process and Chapter 139, Section 19. No Massachusetts statute or rule supports or in any way reflects the intent of the legislature to allow tenants to be evicted as a remedy for contempt or as injunctive relief outside of Chapter 139, Section 19. Therefore, the order insofar as it is a remedy for contempt and as injunctive relief are both improper forms of relief. Neither of them has any basis in Massachusetts law. There are 3 grounds on which we are challenging this order. First, the vacate order is improper as a remedy for contempt. Second, the vacate order fails to include any special factual findings, including no findings regarding Mr. Garnier's reasonable accommodation request as expressly required by the rules of civil procedure and Bridgewater's. Third, the vacate order is not a proper form of injunctive relief. First, the housing court's vacate order is improper as a remedy for contempt because longstanding Massachusetts case law has established that the purpose of civil contempt is remedial. Its aim is to coerce the performance of a required act by the disobedient party for the benefit of the aggrieved complainant. The purpose of civil contempt is often expressly contrasted with the purpose of criminal contempt, whose purpose is punitive, to vindicate the court's authority and to punish the contender for doing a forbidden act or for failing to. Punishment is the purpose of criminal contempt.
So can I ask you the remedial question though? Your client, the landlord, brings an action to stop your client from harassing them. They enter into an agreement of judgment. He violates that. They do another agreement of judgment. He violates that. What is the landlord supposed to do?
Your Honor, here, Mr. Garnier, he raised a reasonable accommodation defense that was, there's not clear if that was considered, but really what happened here is the court used a sledgehammer for an issue that should have been much more narrowly tailored, an issue that should have been much more narrowly dealt with. There is no evidence that Mr. Garnier is a danger to his mother, no evidence that he's a danger to anyone else on the property, yet he was ordered evicted. He was ordered to vacate indefinitely, and that was far disproportionate to what the conduct was alleged, and it's
Isn't the exterminator's testimony to evidence that he was a danger to somebody on the property?
Mr. Garnier disputes the plaintiff's, disputes the exterminator's testimony and the plaintiff's version of the events. And to the extent that he is held responsible for the altercation that occurred, this gets to his reasonable accommodation defense. And anything that happened that would be considered his fault would be getting to his reasonable accommodation defense. This case, respectfully, Your Honor, is just like Bridgewater's, where the tenant was accused of assault on the property and where the tenant informed the judge of his disabilities at trial. Bridgewater's makes clear that a very minimal request is enough for a reasonable accommodation to be considered. And getting back to Justice Massing's question about the remedy being able to be something that can be complied with, there was, for all intents and purposes, a permanent eviction that was ordered here, a permanent vacate order, and Warren Gardens makes clear that that can never be a proper remedy for contempt when it does not compensate the landlord and when Mr. Garnier has no opportunity to remedy that. He was dealing with something that was on the property. He has no way to remedy, to cure that by being ordered evicted permanently or indefinitely, I should say. And so this order cannot stand as an order of, as a contempt remedy for the reasons that I laid out. It's also improper because it doesn't have any special factual findings as required by Rule 65.3 of the Mass Rules of Civil Procedure. Subsection H of Rule 65.3 provides that after trial upon the facts in accordance with Rule 52, the court shall find the facts specially and state separately its conclusions of law thereon. Failure to make special factual findings as required by Rule 65.3H deprives the parties of the opportunity to understand the basis of the judge's decision and for meaningful appellate review. As explained by the SJC in interpreting the analogous provision of Rule 52A, the requirement that the trial court find the facts specially is meant to ensure that the parties involved and this court on appeal may be fully informed as to the basis of the judge's decision. Consistent with that purpose, the SJC held that a trial court's failure to find the facts specially, as required by the law, requires remand. The housing court here failed to find any facts specially. The order merely states conclusively that the court finds defendants Juan Garnier and Yamilet Garnier in contempt for their willful and intentional failure to comply with the court-ordered agreement dated November 1st, 2019, and the court-ordered agreement April 17th, 2020. The agreements together contain several distinct commands of Mr. Garnier, and yet there are no special factual findings that indicate which of the specific commands that Mr. Garnier disobeyed such that he was in contempt of the agreement. Mr. Garnier has also no meaningful ability to challenge this contempt finding, as it is unclear what grounds the contempt finding is based. Likewise, this court cannot meaningfully review whether the remedy, even if a permissible one, which eviction is not, properly serves to coerce performance, as it is unclear in what way the court order was disobeyed. And as I mentioned earlier, Mr. Garnier raised a number of reasonable accommodation defenses that would address any finding of contempt, would address the finding of contempt. He requested the plaintiff accommodate disabilities by allowing him to continue on the premises and asserted that this accommodation was reasonable because he was accessing treatment. Mr. Garnier asserted as a defense that the plaintiff improperly refused to grant his request in violation of federal and state fair housing and disability law.
When did he, was that on the record before the judge?
Yes, Your Honor. Mr. Garnier submitted a reasonable accommodation letter, and that is on page 155 of the record appendix. And also, if I may turn
that doesn't look like it's marked as an exhibit.
If in the record, at the very beginning of the testimony, it was mentioned by Mr. Garnier's counsel that this was submitted to the court as an exhibit prior. I believe it was before the court here. But even on top of that, on page 303 of the record appendix, Mr. Garnier's counsel said, here there are other accommodations to try. He's got new medications. He's got a new therapist. And he has regular appointments booked and monitoring and resources from TPP and other outside organizations. And he's accessing them voluntarily, whether or not there is a court order. And as I mentioned earlier, the Bridgewater's precedent makes it so that all a tenant has to do is apprise the court of a disability, apprise the court of a need for reasonable accommodation. There isn't a very high standard here, because it was clear in Bridgewater's that just saying to the court that I have a disability at trial was enough to trigger the requirement that the court consider the reasonable accommodation request.
What if somebody says I have a need for reasonable accommodation, but then they refuse to follow through on any kind of treatment that might help them with that accommodation? Would they still be able to take advantage of that reasonable accommodation request?
The law contemplates an iterative process and a process where the court works with the tenant who has raised this to find what works. And if something doesn't work, but there's something else that's available, then there's a responsibility to try other things that would work before going to the extreme of an eviction. And here, in this case, there's just no evidence from the record that even what was proposed by Mr. Garnier at the first instance was something that was considered. And so we're still here just at the first stage, and Mr. Garnier respectfully asks that the court consider his reasonable accommodation request.
I have a question, a sort of a housekeeping question about that. There's a letter from Mr. Turk in the appendix dated July 2020 that refers to letters from Lanika White dated June 2020 and Muriana Jenitin dated July 2020, but I can't find those letters in the record anywhere. So my question is, what's before us about what exactly your client has done to try to comply, to fulfill his need for an accommodation?
Yes, so what was those exhibits were introduced after the June 19th hearing, and that's because Mr. Garnier's psychiatrist is a major in the Army and was not available for that trial, but those were available for the judge on his motion for reconsideration. But what was available—
But are they before us?
They are. There's a psychiatric provider letter, and the letters that you specifically referred to, I'm not sure if they're in our record appendix, but if I can go back to the Bridgewater standard here, even just raising that at the trial and what Mr. Garnier's counsel said was sufficient to meet the standard that it be considered. And again, because of what happened, the unavailability of the psychiatric provider, that evidence was not able to be introduced afterwards. But with the remaining time that I have left, I would like to make sure that I have address my third point, which is that the court's preliminary injunction issued pursuant to its equitable authority enjoining Mr. Garnier indefinitely from his home must be overturned because the plaintiff has a plain, adequate, and complete remedy at law. Chapter 239, the summary process statute, plainly allows a landlord to obtain an order requiring a tenant to vacate leased premises. Had the plaintiff brought a summary process action, it could have obtained a vacate order against Mr. Garnier. There's no need for the housing court to use its equitable authority to issue one outside this statutory process. Indeed, the SJC affirmed the impropriety of a court's use of its equitable authorities to enjoin an occupant from their home by way of injunction in Attorney General versus Dime Savings Bank. There, the court explained that equitable relief is unavailable because at common law, a bill in equity brought by an owner out of possession to recover possession of his estate would have been dismissed because summary process offers a plain, adequate, and complete remedy at law. The SJC has made clear that outside the context of 139, section 19, an eviction cannot be ordered via injunction. The court's reasoning in Dime Savings Bank is grounded in its interpretation of chapter 184.18. That statute sets forth the proper legal mechanisms for obtaining an eviction, providing that no person shall attempt to recover possession of land or tenements in any manner other than to an action brought pursuant to chapter 239.
Can I ask on the remedy, if the complaint that started this had alleged one more count under 139.19, could the proceedings have gone exactly the way they did with a preliminary injunction under the statute?
No, they could not have, because 139.19 expressly denies the plaintiff the remedy of a preliminary injunction because they are a subsidized housing provider. And so they would have to have gone through summary process in order to potentially have obtained a preliminary injunction. 139.19 exists as a statutory way to get a faster, a speedier eviction proceeding, but this preliminary injunction was was issued through the court's equitable authority outside the statute. And 139.19 expressly, the legislature said preliminary injunctions not available to subsidized providers because of the policy goal of not allowing subsidized tenants to be on the streets with no alternative in the private housing market.
Okay. I think there was a little clock glitch there, but I think the 15 minutes are up. Let me see if there are any other questions from the panel. Seeing none, thank you very much. We'll hear from Attorney Turk.
Thank you, Your Honors. May it please the court, my name is Jeffrey Turk, and I represent the plaintiff in this action. Your Honor, as I believe the court needs to note, there are no facts in dispute in this case because the defendant at the evidentiary hearing failed to offer any evidence whatsoever on any point, failed to contest the factual allegations regarding this vicious assault, failed to offer any evidence whatsoever in relation to any request for a reasonable accommodation, despite being offered 2 continuances of the hearing date in order to procure that information. As a result, they failed to offer any evidence, and the record is devoid of any evidence which would counter any of the factual assertions made at this evidentiary hearing. As such, I believe it's really just a legal argument at this point, and I believe the first legal issue, Your Honors, is you're being asked to decide that a court in the Commonwealth is barred as a matter of law from prohibiting a person from physically occupying a dwelling unit pending the recovery of possession in summary process, regardless of the ongoing behavior of that tenant. In other words, must a court continue to allow a tenant to physically occupy an apartment, no matter what they do in that apartment, pending an ultimate decision in the summary process?
But counsel, isn't 139.19 the mechanism for a landlord to get rid of a tenant who's violent?
Well, so first of all, Your Honor, not every case 139.19 applies to. So as my brother just said, I find it fascinating that in other cases before this court, they have asserted that with a subsidized tenant, Chapter 139, Section 19 is preempted by federal law and does not allow a landlord to bring an action. They've asserted that in other cases. They assert that in the housing court. And in fact, in a prior case, they argued that it was a breach of contract for the landlord to even serve a notice voiding tenancy in a case where it's a subsidized tenant, and a trial court in the Eastern Housing Court actually found in favor of them on that point. So I don't think they can argue. I believe my brother acknowledged that in his argument just now, that no, it would not be a remedy for a subsidized tenant. Likewise, Your Honor, there's significant amounts of conduct by a tenant that would not come within the parameters of Chapter 139, Section 19. For example, the provision dealing with the use or threatened use of force or violence, which is the provision we're discussing right now, only applies to subsidized tenants pursuant to the statute. And as such, a suggestion that 139.19 is the remedy would not be appropriate because, again, it's not a remedy in cases where it would not be a subsidized tenancy. Likewise, I just want to note, Your Honors, when this case started, it was not a 139.19 case. There were no violations of Chapter 139, Section 19. It was merely a civil action to gain compliance with a lease, in that case to stop harassing. There had been no threats at that point. The ongoing threats against both myself and my client and now then the physical assault which occurred came after the filing of the case. So I don't think to say that it's an adequate remedy of law is correct here, Your Honor. Likewise, I want to note, Your Honor, that in the reply brief, my brother argues summary process is an adequate remedy of law. And I would just suggest that begs the question of what a landlord can do pending summary process. Can a landlord gain?
Can I ask you about that? Pending summary process. It's the order that was issued was as a preliminary injunction in the complaint you brought for the harassment and as a remedy for contempt. I don't see anything about this being preliminary to summary judgment, to summary process.
Well, Your Honor, I don't think it is because obviously it's clear it has to be. I cannot get an execution in a civil case. I cannot recover legal possession of an apartment in a civil action. I can bring an action for an injunction pending my going to court. And I think that's clear because let's also remember the way the summary process works. And this case is a perfect example of it. Before I can even file a summary process case, I have to issue a valid notice terminating tenancy. In this case, 1 full rental period's notice, meaning that if I serve a notice to quit on November 2nd, I can't even bring an action in court until January 1st at the earliest, 2 full months. And by the defendant's argument, that would mean I have no potential to bar any activity for this period, which I'm waiting for my notice to quit to expire. The defendant can do anything they want in the apartment. As Judge Massing seemed to notice, can you do anything in the apartment pending summary process? The only way I can get a remedy to protect the other residents and my staff and the vendors in this case is to bring a civil action to obtain some injunctive relief pending that summary process case. And this doesn't just deal with assaults. The proposition that the defendant is raising here would be goes far beyond that. For example, if I have a tenant that's disabling smoke detectors and starting fires in their apartment, not subject to Chapter 139, Section 19, and they continue to do it, and the judge orders them to stop and orders them to stop again, and yet they continue to do that, threatening life safety, does my client have no remedy to potentially tell that tenant they cannot be in the apartment because they can't safely live there, pending now my summary process case? Do I have no remedy at all to protect the other residents and the staff? And that extends to cases we deal with all the time. People smoking in their apartment and refusing to stop. Cases now where people are having COVID parties in their apartment and we have to go in to get an order for them to stop. And if they continue to violate the judge's order or the agreements and do that, in some cases, the judge may, pending summary process, have to order them physically out of the apartment. It does not dispossess them of their legal right to possession. And my brother used this term evict very loosely. He said it for all intents and purposes, but that's not the point. We do not recover physical possession. The defendant still, in all of these cases, including a 139-19 case, the defendant still has the right, is legal occupant of that apartment. They still can store their personal property in there. In this place, the co-tenant could still stay there. I can't change the locks. I can't re-rent it to someone else, pending bringing a formal summary process action. And even in 139-19, in the Olin decision, the Supreme Judicial Court recognized that even when an injunction issues barring the person from the property under that statute, it does not dispossess them of their right to legal possession. They still have the right to a jury trial. They still have the right to a full adjudication, even though they may be temporarily enjoined from occupying that premise. So I think they blur the distinction between an order which says you can't physically be in this building pending your eviction with it's an eviction. And it's not, because again, we have not recovered legal possession of the premises. We don't divest them of that legal right, no more than when a court issues a 209A restraining order and says you can't physically be in your own apartment. That doesn't mean that I, as a landlord, can say, oh, you can't be here anymore. There's a court order, which happens all the time, sometimes on an ex parte basis. I, as a landlord, can't say, oh, I can change the locks, move all your personal property out. Your right to possession has been terminated. It's merely their physical right to be in that apartment. Courts issue orders, bail conditions all the time that a tenant can't return to their apartment. Again, does not dispossess them of their legal right to possession, as happened here. Mr. Garnier has a legal right to possession, even though he could not physically be there because of the court's findings here. He had a legal right to possession and a legal right. In my brother's reply brief, he says we've divested him of his jury rights. It couldn't be further from the truth, because we look at this case. In this case, we served a notice terminating tenancy. It expired 2 months later. We filed a summary process case in which Mr. Garnier has requested a jury trial. We still, to this day, despite having filed that case 3 months ago, have not even obtained a status conference date, let alone a trial date in that case. So to suggest that he has lost his right to a jury trial on this issue is contrary to the facts and the reality of what's happening here. The judge.
Can I ask a question about what happened? What is the clear and unequivocal command that the defendant disobeyed?
The defendant violated in the court's order. He violated by having contact with the management staff, either by telephone or in writing. Again, the evidence was that after he sent the emails to my office, which I won't repeat what was in them, the court has it in the record, which was a violation of the clear orders of this court that he was not to make those communications. He then called the property manager, used the C word to refer to her, and made a threat against her, again, which is a direct violation of the court's orders. Also, he was not to cause any disturbances on the property. That's paragraph 2 of the first agreement that we reached with Mr. Garnier, not cause or create any unreasonable disturbances on the property. Clearly, the vicious assault of this vendor on the property, which testimony was uncontroverted at the hearing, was a significant disturbance on the property. Again, violation of a clear and unequivocal order of the court. But Your Honor, I think what's also important to note is we very intentionally filed a motion for further injunctive relief and for contempt. And I think the injunctive relief that the court ordered is clear, because I don't know what other injunctive relief the court could have ordered, where we had already done 2 agreements with Mr. Garnier to try to enable he and his mother to remain in this apartment, and he clearly violated those orders. And I think the judge, while we asked the judge to enter a remedy of dismissal of the pending summary process case, she took a lesser order, which was to simply order that he not be physically present on the property. And I think that is also, Your Honor, a clear remedy that the court has as an injunction. This is no different than any other injunction. The defendant seems to suggest that in no circumstances ever may a court bar someone from a property pending a summary process action. And again, I don't just think there are many examples of when a court should do that or may do that. I think this is the prototypical case of when a court should do that. When a tenant, after repeatedly being told not to threaten or harass people, not only expands that beyond verbal harassment, but then assaults a person. Your Honor, I do want to hit the reasonable accommodation issue, because I think that's also a very important issue that's been raised here under the Bridgewater case. And I just want to again be clear to the court. This is not a case where the defendant raised a reasonable accommodation defense. If you look at the record that they cite to, despite being given 2 continuances to counsel to obtain information, they offered no testimony at all on that issue. In fact, they don't even raise the issue until his closing argument. They cite to Record Appendix 303, that's counsel's closing argument, where he says, and he should have been granted a reasonable accommodation. All of the letters that Your Honor referred to, Justice Grant, that you referred to, are not in the record because they never entered them into evidence. So Bridgewater stands for the proposition that was a case where the tenant during the case said, by the way, I'm bipolar. And the housing authority refused to follow their reasonable accommodation process. Here, that was never said until the closing arguments. And it seems that the defendant here is seeking to flip the responsibility to the landlord to raise the issue. Again, how would I raise this issue which isn't raised at the evidentiary hearing? If they had raised it, I would have put into evidence the fact that we had responded, we had followed our process, we had issued a decision on it. They never raise it at the hearing, and therefore there's never an opportunity. I was surprised, actually, Your Honors, that they didn't, because I thought that was going to be their primary focus. But they don't raise it.
What about the May 26th letter to you, citing to Bridgewater's and saying, please regard this letter as an accommodation request?
I agree, Your Honor. If they had entered that into evidence, or if at the hearing they had said, and Your Honor, we are asserting a right to a reasonable accommodation, I would have put into evidence all of those letters and all of our responses to show that we had actually considered this. It had been denied because no doctor had said he was disabled. I would have shown that we denied it because it was not reasonable to allow him to remain. And third, I would have shown that we had processed it and found him to be a direct threat to the safety of the residents. All defenses under reasonable accommodation law. But to suggest that you, as a defendant, can sit back for the entire hearing, not say a word about it, not raise it, and then in your closing argument say, by the way, you should have granted us a reasonable accommodation, I think shifts the burden here. They have to, at the hearing, have made some suggestion. Again, we had all the documentation ready, but I can't be expected to defend a claim that's not made at the evidentiary hearing, despite being afforded 2 continuances to do it. So I think if they had, clearly I would have put those documents into evidence, but they failed to identify those issues or raise it at the evidentiary hearing. They can't do it now.
I have a quick question. Your complaint, paragraph 20, your third complaint for contempt, the one that's at issue here, says the conduct of the defendant has directly impacted the health and safety of the plaintiff, management staff, and other persons lawfully on the property. That seems to track the language of the eviction moratorium without actually citing to it. Are you arguing that that this injunction is exempt from the eviction moratorium?
Well, so first of all, Your Honor, while that may track the language, that is language we've been using for 15, 20, the 30 years I've been practicing. We always use that language as affecting the health, safety, and welfare of the other residents, which I think goes to the injunctive relief claim. I do assert that this was not within the eviction moratorium because, again, it was a civil action, not an action for possession. And the moratorium, which has now expired, so I think the issue is moot, but it did not contemplate civil actions. And in fact, we brought civil actions as an alternative to eviction, which I think is an important point here. This case started because we didn't want to evict the Garniers, especially Mrs. Garnier. We wanted to get compliance. We didn't want to bring an eviction case. And unfortunately, it escalated to the point where Mr. Garnier was unable to control his behavior and cause these assaults. So I don't think it's within the statute or that statute because, again, it was not an eviction. We did not seek possession as part of that case. And we still do not seek legal possession of the apartment. We only seek an order pending summary process, which again, at this point with their jury trial request could take years, unfortunately.
Any more questions? Seeing none, thank you both for your arguments, both very well argued. Good luck in your career, Mr. Ojo. And we'll take it under advisement, and that is that's the last case for today, so we'll be in recess. I want to thank the court staff, Clerk Nagel, and the ones who are behind the scenes for their assistance.